Hello, everybody. How are you doing on this Saturday night? It is 7:14 p.m. on Saturday, November 16th. If you're here in the live chat, hello, hello, hello. Hello, DJ. Hello, 91 Maleli. Who else is in here? I don't know. Lonely Wolf, Nike. Excuse me, the Lone Wolf family. Hello, Natalia. Okay, so last time we talked about the Diddy case, I told y'all that there was a huge filing date yesterday. Okay. November 15th. I said there was two things. This, I think we talked about during my impromptu mini live stream thing. Not impromptu, but my mini live stream. My mini fundraiser. It was not mini live stream. I was on there for 5 hours or something. We talked 5.5. We talked over there about this. We talked about the November 15th hearing. Deadline, like file by date. And yep, it was the Audie hearing, and it was also that one got pushed down the road, kicked the can down the road. I made a video about that one yesterday. Y'all can go watch. What else? So the Jonathan Audie hearing happened, but also, yes, the government did file a response to the Diddy second proposed bail package. Woo! Tell me why. Oh my God. Sorry. I just ate dinner and I drank water and I'm trying to every time I eat anything spicy, I get congested. Every time I get on this microphone, I'm like, it's always something, girl. Whew. Anyway, okay. So there's this 190-page filing, and it is filed in response to Diddy requesting to get let out. Remember, he asked the first time and he appealed it. He's still appealing it. And now he's like, oh, I got all this new information. I got all this new data whenever we were doing the discovery. And so because I have all this new information, all this new data, Your Honor, please, I need to be able to have you reconsider my letting me out. And as another added bonus, I have beefed up, Diddy said to the judge, I have beefed up my proposal such that to include all kinds of things, including, the baby's mother's signing the guarantees for him and the same house in Miami up again. I mean, it all kind of looked the same to me. Excuse me. And if you watch my coverage of the last few Diddy, I do have a Diddy playlist that y'all can watch. I need to add the live streams to them. I don't think I have my live streams in the Diddy playlist. But when I was covering the documents in here, I did say, what is really different about Diddy's new proposed bail package? I don't even think it's as many people has given their passports up anymore. I think the sons might have not even had their passports last time, and now they do. I don't know. I don't remember that. I'm just kind of saying off the top of my head, I think that's what I remember. But then maybe it's these new co-signers or something. I really don't know. Okay. So I have the document here that the government filed in response to Diddy's second proposed bail package. And it's right here, like I said, probably several times now. It's 190 pages long. Okay. So, well, let's just get right into it. I have read the first, I don't know, maybe 3 pages. I really haven't read much because I was getting ready and, like I said, eating dinner. Okay. Here's the preliminary statement. Okay. The government respectfully submits. Newbie. Oh, thank you so much for the 1999 super chat. Newbie Donna Burke says, love your podcast. I think that's what you meant. Thank you so much for that 1999 super chat and for your kind words. Thank you, Ronnie. For the $2 super chat. I don't think we're gonna get a sorry line because I don't actually even own one single sorry, actually. So I probably won't be the one doing the sorry line. But hey, look, listen, anything's possible. I keep a very open mind. Thank you for the $2 super chat. Okay. Excuse me. All right. The government respectfully submits. Okay, so what are we reading again? Hello to everyone just joining. If you are just joining, put a 1 in the chat or something. We are reading. We're starting. I'm just going to start by reading it, line by line, and then we'll see where we end up. The government respectfully submits. line by line and see where we end up. What we're reading here is the response, the government, the prosecutors, the feds, they're responding to Diddy trying to get out of jail. Okay, this is his second time trying to get out. And this is them saying why in that he should stay in jail. This is what they're about to be talking about. I'm sure y'all have seen some headlines and some other stuff floating around out there. If you haven't, it's pretty scandalous what it's being accused that Diddy has done. So let's just like I said, let's just read it. The government, the feds, respectfully submit its opposition to Diddy's renewed motion for bail. So respectfully, no. The defendant's motion, Diddy, should be denied, as 2 judges have already concluded, based on the evidence in the record, Sean P. Diddy Puff Daddy Combs poses serious risks of danger and obstruction of these proceedings. So, okay, third sentence right out the boom. Preliminary statement. No, we oppose. Please deny. 2 judges have already concluded Diddy is a risk to obstruct these proceedings, and he's also a risk of danger. So no, you got to keep him locked up. The filing goes on. In seeking a new hearing, Diddy rehashes the same arguments rejected by those 2 judges with claims of new evidence. Okay, so listen, sorry, Your Honor, no. He's just saying the same crap over and over again. He's already said all of this stuff before. In fact, the only truly, quote, new relevant evidence shows that Diddy has continued to engage in a relentless course of here, make that part bigger for y'all. To engage in I'm reading straight from the filing right now. To engage in a, quote, relentless course of obstructive conduct. This is what they're saying Diddy's doing. They're saying, Your Honor, the only new thing, if anything is new at all, Your Honor, respectfully, it's that Diddy is showing his whole entire behind. Okay. He's putting it right here in the filings, clear as day, that he's continuing to engage in a relentless course of obstructive conduct designed to subvert the integrity of the court proceedings, as described in detail below. Okay, so they're going to describe it in detail below. This is 190. It's 190 page filing total. But I will tell y'all, look up here at the top, see how it says in the blue. Sorry if you read blue colorblind. I'm waving the little mouse click thing, the cursor around over here, page 5 out of 30. So I think it's 30 pages of like typed out. And then I think the rest is just exhibits and signature pages and stuff like that. But we are being told here in this filing, in the preliminary statement, first freaking paragraph, we're going to describe it in detail below, Your Honor. But while Diddy was attempting to evade law enforcement monitoring, he has, among other things, orchestrated social media campaigns. Oh, my Lord, have mercy. It is black and white. Sorry if you colorblind. I think y'all can still see black and white. Among other things, what did he do, y'all? Orchestrated social media campaigns. Okay, so I remember, raise your hand, put a 1 in the chat if you have been around long enough to remember whenever we were covering like the Free Britney movement or the Free Bam movement. Remember? Put a 1 in the chat. And I would say things such as, I believe that the plants are part of an orchestrated social media movement. I believe that it's orchestrated. I believe that these people, for example, Free Britney America, I believe that that was one such type of a situation. It was like an orchestrated PR something to like appear to take over the Free Britney movement, or appear to always have been in it, which they were not. No one ever heard of them. And then poof, out of nowhere, they're in the freaking Fox News van doing interviews on the behalf of the whole Free Britney movement. We didn't even hear their names for like a month before, until a month before that. It was very weird. We had been begging and begging for news coverage on this story for years, and these people showed up out of nowhere having connections to Congress people, y'all. It's like I might have been born at night, but it was not last night type of situation. Like that was an orchestrated social media campaign, y'all. One of them was a convicted on a registry child, you know what, offender, and was going by a little bit of a different name, switching his first and the last name around. Oh yeah. Oh yeah. And do you remember when we were talking about that? And it was like what people worse, anybody that would even address it at all, other than us that like all agreed, right? Like anybody else that would address it outside of like we the people, it was like we were being conspiracy theorists, girl. We were being conspiracy theorists because why would somebody do that? Why would there be a social media, all this, you know what I mean? Like the detractors, like trying to like tell me that the freaking sky isn't blue or whatever, you know what I mean? But look at it. We looking at, I feel vindicated. I needed to stop and tell y'all that story. And I thank you for all the ones in the chats. I see them. I see them. I see them. I see them. Thank you very much. Yep. And so, yes. So look right here, black and white. The government says on the first paragraph of the preliminary statement saying Diddy should absolutely not have his behind outside of this jail in any way, shape, or form, Your Honor. He has been cutting up even in jail. We are going to tell you about it in detail below. But among other things, what did they say he did? Orchestrated, all alleged, okay? This is allegations. I wasn't there. I don't know. Neither were you. And if you do, you need to go, be a witness for the feds and get out of this chat, or you could stay in it, as is your right. You probably should be in here, actually. Thank you. Click the like. Innocent until proven guilty, but this is an allegation in black and white on the behalf of the government, right? On the behalf of the government. So this isn't a Free Britney conspiracy theory. This is the government saying it now about a different situation, right? Orchestrated social media campaigns that are, in his own words, aimed at tainting the jury pool. In his own words. Well, I'm looking forward to the details below. Put a 2 in the chat if you're looking forward to the details below. He also apparently, allegedly, according to the government, made efforts. If y'all are super chatting and super and all of that, and thank you very much. I'm gonna have to look away from the chat for a minute so I can get through some of the court filing, and then I'll get back to those in a minute. So thank you very much for that. And I'm gonna have to turn my comments off because I get so distracted. I want to have a coherent explanation of this. It's important to me that y'all actually understand what's going on. So thank you for the super chats. Thank you for all that. I will get to them. But let me get through a little bit of this filing first. Thank you. Okay. As described in detail below, while attempting to evade law enforcement monitoring, Diddy has, among other things, orchestrated social media campaigns that are, quote, in his own words, aimed at tainting the jury pool. Also, allegedly, according to the allegations that the government is making, Diddy made efforts to publicly leak materials that he views as helpful to his case. And he contacted witnesses through third parties. Okay, so while attempting to... Okay, so I don't know if this is them saying it happened in jail or not. So this part is a little ambiguous. So let's read further. For these reasons, the court should deny the defendant a new bail hearing. To the extent the court decides to reopen a bail hearing, however, Diddy's application for bail still must fail under the Bail Reform Act. His motion ignores the significant evidence presented by the government at the prior hearings, showing that, okay, so they're saying, okay, look, listen, Your Honor. First of all, the fact that all that first stuff we just said, the social media campaigns he's been orchestrating, allegedly, trying to taint the jury pool, trying to leak evidence, for all of that deranged, degenerate behavior alone, you need to keep him locked up. But Your Honor, if you think for some reason that's not enough, there's another whole reason that it should fail, and that whole another reason it should fail has something to do with the fact that Diddy's motion is ignoring a very important point. And the very important point is there's nothing new. He has to say something new. The judge has already decided to keep him in jail. Several judges, many judges have decided to keep him in jail. And so, barring unless there's something truly so new and so monumental material, right, that it should warrant complete reconsideration, like that's just not does not here, the government is saying. It's just nothing new. He's bringing up Cassie's lawsuit. He's bringing up all this crap you already knew about. Nothing's new. Okay. It says his motion ignores the significant evidence presented by the government at the prior hearings, showing that Diddy is a, quote, violent serial abuser who uses his vast wealth and position in the entertainment industry to conceal his illegal conduct and to prevent victims and witnesses to this abuse from coming forward. Okay. So his motion is ignoring a big red flag, Your Honor. And that's all of the evidence that's before Your Honor, before your court, that shows he's deranged. He's a violent serial abuser. He uses his money and his power and his position in the entertainment industry to hide illegal conduct. Okay. Remember all that evidence you saw of that, Your Honor? Remember that? Diddy's motion completely ignores that. Is what that's what's being argued here. Excuse me, I'm having, I don't know, a little sinus problem or something. Okay. In light of the well-documented danger posed by Diddy, the updated proposed conditions of release are woefully insufficient to assure the safety of the community or the integrity of these proceedings. Okay, so we have two major problems, Your Honor. First of all, he's dangerous. We got a community safety concern, Your Honor. On top of that, let's say we could somehow make sure he ain't going to hurt anybody or whatever. How are we going to make sure that there's a fair trial? Because he's intimidating witnesses, tampering with this and that, and he's over there squawking about a fair trial, but he's directly interfering with the fair trial himself. Indeed. Sean P. Diddy Puff Daddy Combs' continued obstructive conduct confirms the conclusion reached by two other courts. No set of conditions can meet that task. No set of conditions can keep the community safe and keep the proceedings safe. That's what the government is saying. Sean P. Diddy Puff Daddy Combs' request for a, quote, temporary release should also be rejected. So he also asked for a temporary release. Like he asked for like full out bail. But he's also asking for this like other alternative route, like a loophole, like using a different law or whatever. And they're like, nope, that fails too. No, absolutely not. His confinement at the Metropolitan Detention Center affords him more than adequate opportunity to prepare for his trial. Remember, he was talking about he needs a laptop, he needs a notebook, he needs a pen. They came through, they did a security sweep. They rifled and ruffled and tossed and turned his stuff. And y'all got mad at me because I a little bit saw his point a little bit. Like I'm thinking, about somebody in there innocent. And it's like, somebody's innocent and they're trying to prepare for their trial. Like I'm thinking, what if it was me? What if I'm in there innocent? Because I know what it feels like to be falsely accused of stuff with this litigation that I'm in right now. It's like these people are literally just freaking lying, and they seem to be they appear to be very comfortable doing so. And it's like, for freaking wow. And so it kind of broke my reality a little bit. And I'm like, well, I would want a pen, and y'all are coming for my neck. It's because karma. He deserves it. What about the people he locked up? I'm like, yeah, girl, but I mean, like, okay. So he's fussing and hollering about all they can't even have a pen. They're rifling through his stuff and won't let him have a notebook. Won't let the lawyer in because they're doing all these security sweeps. He's complaining. He's saying it's not fair. I kind of do feel like it's not really fair, but y'all resoundingly disagreed with me. So the government's saying, no, boo-hoo. Your conditions are fine. Shut up. That's basically what they're saying. His convenience does not provide a basis to reevaluate the danger to the community and the threat to the integrity of these proceedings that he poses. Okay, so they're basically just saying, okay, this has nothing to do. Oh, I don't want the screen. This has nothing to do with a due process and all that. He just wants more convenience. So no, he's dangerous. Reiterated. Okay. So that was the first paragraph called the preliminary statement. That's kind of like the roadmap. That's what we should expect. But we're going to get some details coming here below. And I'm looking forward to seeing what it is that the government is going to argue why it is that Diddy should not be let out, because they got some new information in here. And it seems, based on the headlines I've been seeing, to be a bit scathing. All right. After nearly a year-long investigation, whoo, wow, nearly a year long. So I think they started investigating Diddy around the time of the Cassie filings, which was November 2023. So after nearly a year-long investigation, an indictment was filed on September 12th, 2024, charging Diddy in 3 counts. Number 1, racketeering conspiracy. Number 2, ST ficking. And y'all are like, why can't you just say the word? I don't know, girl. Ask the terms and services. I'm just trying to stay on here and keep everybody happy and keep telling my little stories here. Okay, so charged with 3 counts. Number 1, racketeering conspiracy. Number 2, ST. And 3, interstate transportation to engage in prostitution. As alleged in count 1, Sean P. Diddy Puff Daddy Combs participated in a racketeering conspiracy since at least 2008. Specifically, the government says the defendant, as charged in the indictment, right? They're citing their indictment. These are all allegations and charges until proven or unless proven. If they're never proven, then, he's technically, innocent. He might literally also be innocent. Literally. I don't know. I wasn't there. I keep telling y'all. 3,000 people in the chat. Let me get a sip of water for that. Okay. All right. Your Honor, just as a reminder, they're kind of saying, just on count 1 out of 3 alone, just count 1, just one of the 3 counts. It's alleged that this man was participating in a racketeering conspiracy since at least 2008. Specifically, as we told you or charged him with in the indictment, Diddy often assisted by other was often assisted by other members. I think that's what it says. It might be a typo. I'm just trying to fill in the blanks. Y'all can read it on the screen what it says. But I think what the government's trying to say is that Diddy was often assisted by other members, or the conspiracy was assisted by other members, engaged in ST and engaged in acts of violence. And these acts of violence, Your Honor, just to remind you, included kidnapping, arson, and physical violence, among other crimes. Again, these are allegations until proven. As the indictment alleges, from at least 2008 through 2024, that's this year, Diddy used force, threats of force, and coercion to cause women to engage in sexual activity. And that includes acts with male commercial workers that the defendant referred to as freak offs. Okay, so they're just kind of saying, look, Your Honor, Mark Agnifilo. Whoo, girl, Your Honor, whoo, sir. Thank you. May it please you. Mark Agnifilo just said a lot of stuff over there in his filing. I'm doing a translation right now to catch us up to where we are. Mark Agnifilo said a lot of stuff over there, Your Honor. I understand if you got a little bit lost in the sauce, we got a little lost the trees from the forest and all of that in it. So I'm just going to remind you, we're talking about kidnapping, arson. We're talking about the freak offs. Remember those? So this part of it is just walking the judge back through, like, to remind him and reiterate what's really already gone on, because all this about this and that, this man is dangerous is the argument. These freak offs sometimes lasted days, were elaborate, Performances, performances. These freak-offs, which sometimes lasted days, were elaborate performances that Diddy directed, did certain things to himself during, and often electronically recorded. Diddy ensured that female victims participated in freak-offs through coercion and violence, including by supplying them with controlled substances, subjecting them to physical, emotional, and verbal abuse, controlling their careers, livelihoods, housing, and threatening to disseminate recordings of the freak-offs. The government goes on, in connection with this conduct, count 2 charges him with ST, victim 1, which is Cassie, by force, fraud, and coercion. And count 3 charges the defendant with count 3 charges him with causing interstate transportation of others for the purpose of purpose of prostitution. And then they say he was arrested September 16, 2024. He was presented and arraigned the following day before Honorable Robin Tarnowski. And following his arraignment hearing, the government moved for Diddy to go to jail under the Bail Reform Act. Because Diddy was charged with ST, detention is presumed under the Bail Reform Act. Okay, so what that means is there's a special certain law that they have in place, a statute called the Bail Reform Act. That is the federal law under which they argued that Diddy should remain in jail. They said, pursuant to the Bail Reform Act, Diddy got to stay in jail. Okay, so what is the part of that act that they're talking about? They're talking about a part which has a presumption built in that if a person is charged with specifically ST, they not getting out of jail, all right, until the court date. That's the presumption. It's like assumed. It's like required by law, So there can be exceptions, and that's what they keep going back and forth about. They keep arguing, well, Your Honor, this judge in this other case decided that the client should be free. Look what they did over there with the Abercrombie guy. They let him free. Diddy should be free. And the government's like, no, the Abercrombie guy has nothing to do with this. There's all these other different, whatever. You know what I mean? They're arguing the nuances of the Bail Reform Act when they're arguing about whether Diddy should get bail. So they're arguing over the Bail Reform Act. Well, the government is saying, he was charged with ST, Your Honor. His detention is presumed. It's presumed he has to stay in there. Presumed. No, presumed. Sorry. Too bad, so sad. Sorry, Charlie. After hearing argument, the judge found Diddy had not rebutted. He hadn't overcome that presumption, right? The presumption built in, but he could have got an exception. No, he couldn't get no exception. Hell no. You go into jail. There were no conditions. On top of that, there's this technicality, right? There's two things going on. When I say technicality in this particular case, I don't mean to minimize the severity of it. I do think I understand what they're talking about. But as I just explained, they're arguing the nuances of the interpretation of a statute. They're arguing how should the judge interpret the Bail Reform Act. And that could come down to technicalities in a textbook, for example. But the government has another trick up their sleeve. They have another argument. They're saying, on top of that, Your Honor, that first judge in the very first case, she wasn't just talking about the little nuances of the Bail Reform Act. No, She found, Judge Robin Tarnowski found there was absolutely no condition at all that could possibly be combined and put in place to make sure Diddy was not going to still pose a danger to not only the trial, but also the community. The judge already found it. That's what's being argued here. Judge Tarnowski already found it. There were no conditions that that would reasonably assure that Diddy wasn't going to be a danger to the community. That judge here, what we're reading is like a second time that Diddy is trying to get bail, but they're like, we've already been there, done that, Your Honor, and here's what they decided. Okay, so this is a walk down memory lane, reminding the judge what had already happened here. Judge Tarnowski didn't just say, oh, the Bail Reform Act, presumption, blah, blah, blah. No, on top, let's pretend that that thing doesn't exist. The man is a danger. This is a whole nother argument, whole separate argument up their sleeve. He emphasized, I think Robin is a she, I think, emphasized, the first judge, the serious nature and circumstances of the conduct that Diddy was charged with, which largely, quote, happened behind closed doors and was therefore difficult to monitor. So the judge is like, y'all, these are some pretty serious allegations, first of all. And second of all, a lot of this stuff happened behind closed doors. You're trying to go right back behind closed doors. We're not going to be able to see you. No, you need to go in jail. Sorry. That's kind of the walk down memory lane. Judge Tarnowski noted, quote, indications in Diddy's history and characteristics, quote, that he would present a danger to the community, and the judge dismissed as inadequate the exhortations from Diddy's counsel. All of the bump and gums that Agnifilo, Diddy's lawyer, was doing, the judge just, no, shoo, no. He said, you, Mark Agnifilo, I'm sure that you would love to believe that you have some type of, I'm paraphrasing here, I wasn't in there, I don't know, but basically I'm doing a little rundown. The judge said, Mark Agnifilo, please, I'm sure you would love to believe that you can wrangle Diddy under your control, but you cannot. And so that's completely inadequate. You're not going to be able to keep him under your control, right? Diddy's lawyer. Do y'all remember? So much stuff happens that I just forget some of this funny stuff until it comes back up. Or unless it comes back up. But do y'all remember whenever Mark Agnifilo was like, I am asking Your Honor to trust me and my client. Not only my client, but to trust me. And it was like, no. The judge was like, no, he has anger issues of abuse, issues of presenting a danger to the community. No, Mark Agnifilo, we're not going to put you in charge as the babysitter. Thank you. So have a seat, The judge highlighted that the weight of the evidence was significant. Okay, so even though it hasn't been decided, and even though the judge hadn't made a decision, even though the jury hadn't heard it or anything like that, the judge is still entitled, and I think even in some cases required, to look at the evidence that so far in the case has been presented, even up through the discovery phase. And every time whenever they file this stuff, they're filing exhibits on the back, right? Emails, and a lot of them are redacted from us. When we read over it, we see all these black bars and all of that. So those don't look like that for the judge and for the, the judge and the people in the case. So the judge can look at that evidence and other evidence that has been brought before the judge to decide, does he pose a danger, right? Is there actually evidence, like, for example, a tape of him kicking somebody in a hallway or something, like looking at the evidence as the judge had it before her at the time, highlighted that the weight of that evidence was, quote, significant, given the multiple witnesses that observed firsthand Diddy's, quote, violence and coercion. Diddy appealed that decision to Judge Carter, to whom the case was then assigned, and a bail hearing before Judge Carter proceeded. Okay, so this is the second judge. We're walking through memory lane. After a lengthy argument, Judge Carter, denied the defendant bail. So that was the second one, right? Judge Carter, So the first one, Tarnowski, Now we got Carter the next day, next. Now this judge found specifically that the government had, quote, proven Diddy was a danger regarding the obstruction of justice and witness tampering by clear and convincing evidence, and Diddy is a danger to the safety of others. Okay, so not only, again, Judge Carter independently on his own found that Diddy is a danger not only to the community, even if you could somehow get over that one, you still have a whole nother reason to keep him in jail. And that is he's a danger to making sure we have a fair trial because he's tampering with the case. So the fact that there's all these different grounds to keep Diddy in jail, the way I see it, at least 3 or 4 possible different combinations of circumstances and decisions that Diddy has to stay in jail, and like a 1/16th chance that maybe he could possibly somehow get out, and it's dwindling. Like I'm just, looking at all the parts and moving them around. Cause it's all these different ones. It's like, all right, let's say he can get over he's not a danger to society. How's he going to get over the witness tampering? And this is the evidence that we already know about, right? This is all of this so far as a walk down memory lane. The filing we're reading right now is called, as you saw in the title, New Docs Just Dropped, and they make a bunch of new allegations we're going to get to. I haven't gotten to them. I mean, it's like a live react, like the title says. Okay. So that Judge Carter, second judge, nope, next. Now, the filing says, although Judge Carter did not rely on risk of flight, he noted that the bail package proposed. Okay. So when the judge was making his decision, like technically, he didn't really even address this flight risk situation aspect of it, right? That's just one of many things that Diddy has to overcome to show that he's not a risk of getting on a plane or a boat or a tunnel or whatever and getting them out of here and never, nobody ever hears from or sees him again. Now they're saying, okay, this second judge, he didn't even base his decision on this flight risk thing, but I know that we might end up needing to argue about it. So let me just get it in here right here real quick, Your Honor. That judge said that the bail package was still insufficient to address the flight risk. So even if we get past all this other stuff, I'm just reminding you, we also have that little flight risk issue that we still have to deal with. Ultimately, the filing says, Judge Carter found that there was no condition or combination of conditions that would reasonably assure the safety of a person in the community, or that Diddy would not obstruct justice. So again, same two things again. He's going to mess with the outcome of the case, and he's going to be a menace to society. He was remanded and put in prison. Okay. So they talk about the Bail Reform Act. Specifically, a bail determination may be reopened before trial if the judicial officer, that means the judge, finds that information exists that was not known to the movement. That would mean Diddy. Okay. So information. So this is what the test is right here. Okay. For what Diddy has to prove. And the government's like, he's nowhere near this, Your Honor. The man is delusional. This is what he has to prove. The bail determination, once it's been determined, you may reopen it under a certain circumstance. And one of them is, quote, before trial, only if the judge finds that information exists that Diddy did not know at the time he first had his first hearing on bail. Okay. Not only that, this new information has to have a, quote, material bearing. It has to have a material bearing, has a material weight on the issue of whether there are conditions of release that will reasonably assure the appearance of such person as required in this. Okay. Okay. So what exact little nitpicky, little tedious, little detail are we actually needing to convince the judge of in this actual filing, if you're curious or wondering, is remember how Judge Tarnowski and Judge Carter both found that there were, quote, no conditions of release that could assure community safety and could assure he wouldn't obstruct? Well, what if there was some condition of release that could assure the community safety, right? This condition of release, like what if it was a certain ankle monitor? What if it was a certain combination of security guards and police officers and right? Like that's the question at issue. Excuse me. Sorry. Now, the government goes on to say, but hold on, Your Honor. Hold on. However, a bail hearing should not be reopened on the basis of information that was available to Diddy at the time of that first hearing. Then what were you just going to keep coming back here over and over on crap that he already knew? No, stupid. Okay, it has to be new and material. We're not going to get too in the weeds on this. And then they talk a little bit about the temporary release thing where Diddy's like, okay, fine. If I don't get full bail, can I at least be temporarily released? Because I don't even have a pen. They won't let me have a pen. They won't let me have a notebook. They doing all these sweeps. They're ruffling and rifling my papers and doing sweeps. And Your Honor, I need to be let out because there's 11 terabytes of data and I need to look at it all. They won't let me have a laptop. It's not fair. Let me out at least for a minute, so I can prepare. Well, this is where the government addresses that aspect of the argument and says, Section 3142I provides that a court may permit the temporary release of a person, including, maybe Diddy here, in the custody of the prisons, the feds, to the extent that the judge determines such release to be necessary for preparation of the person's defense or for another compelling reason. So basically, like a fancy way to just say the judge has some discretion on whether to let Diddy out temporarily or not. And it's up to the judge, and they kind of leave it up to the judge. And this is the statute they cite. Quote, this provision has been used sparingly to permit a defendant's release where, for example, he's suffering from a terminal illness or a serious injury. So in the past, it's been used when people are like dying or they have a very serious injury. In considering whether release is necessary for the preparation of the person's defense, and see, they put it in quotations like this because they're trying to say like necessary for the according to the law. You know what I mean? Like, you know what I mean? I'm saying it like that because, that would be a context where you would be able to identify what I'm talking about. But like in considering whether the release is under the law, under the case law, under the what's been decided, the precedent and all of that, what does it mean to be, quote, necessary for preparation of the person's defense? What does it mean for something to be necessary for Diddy to prepare for his trial that he can't get inside of the jail? Because like I said in my coverage, if Diddy is not getting a fair trial in that jail, then nobody is. And then we need to revamp the whole system because I don't think he's getting especially treated. I don't think everybody else gets to have a pen and not Diddy. That would be a different issue. You see what I'm saying? Okay. Okay, so when considering that issue, the Bail Reform Act simply requires that a defendant in custody, so Diddy, be, quote, afforded reasonable opportunity for private consultation with counsel. And this I feel like is, I'll refrain from going into too much detail, but I would be remiss not to interject my own opinion right here that I don't think this is like constitutional or fair. I think that you should be able to adequately participate in your own defense, including have a notebook and a pen. Now, some of y'all were saying, well, what if Diddy was going to do something with the pen? Hurt himself, hurt someone else. What if this, that, what if that? Listen, y'all, I'm not trying to say that I'm the decider. I'm not even trying to say Diddy should have a pen or a laptop. That's not what I'm saying. I'm saying I see the argument. And I'm like comfortable, like not picking a side on stuff. Like, I feel like there's been this like push for some reason, like everybody got to pick a side and be binary and have an opinion on everything. Like I can see both and I want to read the arguments and stuff. That's what the judge is supposed to do. I mean, I should hope the judge at least is doing that. Okay. Okay. So that's that section, so they're basically saying, no, leave his ass in jail. They're basically the government is agreeing with my comment section because y'all do not have one grain of ability to see any argument. If Diddy's lawyer's making the argument, some of y'all, not all of y'all, I know a lot of y'all do see both sides. But some of y'all, the ones that's like very vocal in the comments, y'all are like very on the same side as the government on this argument right here. Okay. So they move on to the discussion section. They're like, no, Your Honor, keep him in jail. And here we're gonna enter the discussion section. Why? The court should reject Diddy's attempt to reopen the bail hearing based on the same information he presented to Judge Carter. Diddy's motion to reopen the bail hearing should be denied for the simple reason that he has not presented any information that was not known to him at the time of the bail hearing before Judge Carter. Because remember, we just went through that whole entire little, lesson on statutory interpretation, but it was for the point of y'all understanding the rest of this filing, right? Because the whole thing's going to keep coming back down to some very familiar points now, because hopefully I've explained it in such a way that now y'all understand what it is that they're arguing about, right? Diddy had to do two things. Two things had to happen. Number one, he had to have not known the information that he's trying to now get bail. He had to have not known it at all. Known the information that he's now using and relying on to try and get bail a second time. If he knew it, any of the information, then he cannot rely on it. Okay. That he had to do that. He had to not know it. The other thing he has to do and had to do, and the government's like, no, he didn't do it, is it has to be new information. It has to be new. It has to be something that he didn't have any access to. Okay. As set forth below, Diddy asserts that the court should consider so-called new information, and they put it in quotes, relating to the defendant's relationship with Cassie and his communication with various witnesses as basis to reopen a bail hearing. Okay, so what is the basis? What is the basis that Diddy is trying to use to open the bail hearing? It's stuff about his relationship with Cassie, and it's also Exhibit A. And Exhibit B is, point B is Diddy is now trying to say some of this new information is communications with various witnesses. The government says, but these allegedly new facts are the very same arguments he already done made, and they already got rejected by the district court previously. And now he wants to dress it up with recent new discovery. But all these facts were well known to Diddy before any discovery production. And because Diddy already relied on them, he already relied on all this information. There's nothing new here. He cannot recycle his arguments here to revisit the sound determination made by Judge Carter that defendant Diddy is a danger and a risk. And a risk to obstruction, and he must be detained. The defendant claims that communications between the defendant and one were recently produced in discovery as part of his electronic devices and accounts. It's new material. Yeah, so he's saying, okay, Diddy's trying to claim that this reveals a loving, at times toxic, long-term relationship between two adults who decided mutually to break up. No, this is nothing new. He already said that before. Furthermore, in presenting recently produced text messages, he cherry picks to paint a misleading picture. Okay, so no, Your Honor, no. He also only picks a few little ones that make him look good, and it's lies. It's misleading at best. He ignores a whole bunch of other messages in the record between him and victim one, that's Cassie, documenting his physical abuse of her and his threats to expose recording freak-offs. Okay, so ding, 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 if y'all have your notebooks and you're keeping notes. This is a new allegation. I mean, I don't know. Maybe it's not. I have a hard time keeping up and remembering every single thing that was ever said, but this feels new to me, right? This right here. Diddy wants to put a bunch of, the government said, Diddy wanted to put a bunch of text messages in there, cherry picking through to make it look like him and Cassie had this great relationship and all of that. But you know what he didn't put in there, Your Honor? What else he also has access to? The evidence he was abusing her. That. The evidence of him threatening to expose her freak off tapes. He sure didn't include that as an exhibit, Your Honor, is what's kind of being said here. Here's one text message. Whew, TW. Okay, quote. This was supposedly allegedly from Cassie. You know what's sick and disgusting, beep, I was reminded of the other day? This is Cassie to Diddy, allegedly, according to the government. You forcing me to, omitted, beep, or you were going to leak some freak off stuff. Quote, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. This is allegedly, supposedly a text message exchange from Cassie to Diddy. I mean, I believe victim one is Cassie, but we don't know. It says victim one. The quote goes on. The government is including this to say, Your Honor, you can't let the man out of jail. This is a reason. This is the quote. Quote. I turn my head for a second and you get effed up and you drag me down the hall by my hair. I have bleeding cuts. You hit me in the head 2 good times. When you get beat up the wrong way, you always want to show me that you have the power and you knock me around. I am not a rag doll. I'm someone's child. Moreover, okay, so that's the end of the quote. The filing goes on to say, moreover, despite attaching lengthy text messages between Diddy and Cassie on various dates between August and November 2018, he sure does leave out messages produced in this same thread about the defendant's violence, about his own violence, and then they redact. He also rehashes his attacks on Diddy. The defendant, that's Diddy, also rehashes his attacks on victim one's motives. Okay, so he reiterates his attacks on Cassie's motives in bringing a civil lawsuit against him, like saying it's a money grab and all that, right? So he already said that before. So I don't know why he's saying it again, because the last 2, 3, 4, 50, 11 judges didn't buy it. So why is he still trying to do that whole money grab thing? Please. Across multiple bail hearings in the instant brief, Diddy has made clear that his litigation strategy is to personally attack Cassie, stooping to any depth to attempt to undermine her credibility. Okay, so this is what the government's saying about Diddy. He's just obsessed with undermining Cassie's credibility. Setting aside this questionable strategy, the government goes on, none of the information that purportedly undermines Cassie's motives wasn't known. Hold on. Setting aside the questionable strategy, none of the information that undermines her motives was unknown to Diddy. None of this was unknown. He knew it all. Again, his lawyer made all of these arguments already. And these arguments have no bearing on the question of bail. Whether or not Diddy is money hungry, whether or not Cassie's money hungry, whether she did something out of motivation for spite or this or that, whatever Cassie's credibility is, has absolutely nothing, the government is saying, to do with the question of bail. We have a lot of other evidence besides Cassie's credibility, okay? The purpose of a bail motion is to determine whether there are conditions that will assure the safety of the community. Remember, I said we would keep coming back to this point. The purpose of the bail motion is to get back to this point. Cassie's credibility don't have nothing to do with this. It's to determine this, whether there are conditions. Can we come up together by hook or crook or crook or whatever to get some conditions to let Diddy out? Because the purpose of the Bail Reform Act was that they were jailing too many people. People were getting thrown in jail and it was not fair. And there was some racial, disparities and things. And so they were like, let's not just have everybody just sitting in jail, but how about, for certain crimes, we do got to have people in jail, especially if there's a lot of evidence for it. And we'll even give them a chance to get out of it. There'll be an exception. It's not a for sure, it's like a hearing can happen and all that. But if you are accused of ST, you got to go to jail. Okay. We're going to starting point. That's starting point. Okay. But you can try and argue why you shouldn't and why the government don't have evidence, and we can do all that. But that's why the question comes down to, is there any condition that can assure the safety of the community? Because there is a presumption under the Bail Reform Act. They don't want people just sitting and rotting in jail if they don't need to. So there's really a presumption that Diddy shouldn't be in jail. But then you add on top of that a certain charge, the ST. And then you add on top of that, there's some evidence that the judge gave significant weight to. To the extent that Diddy takes issue with Cassie's credibility, a trial is the appropriate forum to address that. The court should reject Diddy's request to reopen the bail hearing because Diddy disagrees with the government's use of the term victim. I don't know what this is about. Let's see what he's talking about here. The defendant next accuses the government of misleading the court as to the nature of certain of the defendant's communications with another victim, victim 2. Okay. So we're talking about victim 2. And let's read further. The government did no such thing. Diddy's primary point of contention, what's his point of contention? The government's characterization of this individual as a victim. Okay. In quibbling, so they're accusing Diddy's lawyer of quibbling. Quibbling means to just like get caught up in the weeds frivolously, foolishly, unnecessarily, has nothing to do tangentially with the point. In quibbling about how to label victim 2, an individual to whom Diddy continues to pay a significant monthly sum. Okay, this is one of the things that I did see. There is somebody out here that Diddy is paying a, quote, significant monthly sum to this person. Money, monthly. They are calling this person victim 2, all right? The defendant, Diddy, does not present any new information or grapple with the actual evidence. The messages and recordings between Diddy and victim 2 on which the government relied at the initial bail hearing are clear on their face and consistent with the government's representations. The defendant was leveraging significant financial benefits to cause victim 2 to adopt his narrative of their relationship. Okay, interesting. Whoa. This is wow. Wow. I'll make this bigger so y'all can see this. This is wow. This might take me a second to unpack. Okay, so wow. So what we're talking about here, Diddy and his team have a problem with, there's a person, well, there's a John Doe. Okay. And this John Doe, instead of calling him John Doe, because we have a lot of those now, we're going to call him victim 2. All right. Victim 2. Diddy is saying, hell no, that's not a victim. No. Mark Agnifilo and Diddy said that wasn't a victim. It wasn't a victim. He was a et cetera, XYZ. I don't know. I'm just filling in the blanks here, right? You can look at what I'm basing it on. It's up on the screen. Diddy accuses the government of misleading the court as to the nature of, okay, I see. Okay. So there were allegations that Diddy was communicating with victims. Diddy said, I never communicated with any victims. Actually, I communicated with this other guy. And the government's like, yeah, that's one of the freaking victims. But I would say, to Mark Agnifilo's point, he's been arguing the government needs to name the list of victims because there seems to be a point at issue, right? We've been talking about this. I even said this in my Tanea title. It's like some people, we've been talking about this for Quiet on Set. It came up. It keeps coming up. It's like people are victims And then sometimes they become victimizers and it's complex, right? So they're saying, yeah, one of the people you communicated with is one of the victims, victim two. And Diddy's like, no, that isn't a victim. That's my like freak off buddy or whatever. I don't know. I'm just making it up because a lot of this stuff has been redacted, but we can backwards like piece it together based on, you see what I mean? Look, tell me if I'm wrong. That's why I said it's going to take me a minute to unpack this. The defendant, that's Diddy, defendant D, defendant Diddy, okay, accuses the government, the feds, of misleading the court. Diddy's accusing us of lying to you, Your Honor, as to the nature of a certain relationship that he had with another victim, victim two. We did not mischaracterize. Jack Beep, that's a Diddy victim. Yes, it is. It meets the statutory definition and it meets the statutory requirements to be a victim. That person might not need to say they a victim. The law can apply to a victim whether the victim knows. Does it ever say in any laws you only a victim of R if you believe you are? No. No. Like if the government determines that you were robbed and you're like, I'm not a victim, but you were in fact robbed and someone, gets arrested for it and gets charged with it and gets convicted and goes to jail, you are by statute a victim. Now we have, I talk about this all the time. People like to change the meanings of words where it's like, I don't want to be a victim. And it's like, that's fine. You don't have to. But we talking about very specific definitions right now. And it's like, does it meet the definition of a victim is what the government is saying. And Diddy's like, that ain't a victim. And they're like, want to bet? Roll the dice. The defendant, Diddy's primary point of contention appears to be the government's characterization of this person as a victim. And getting all caught up in the weeds about who's a victim and who's not a quote victim, stupid. Diddy does not present any new information or really discuss any actual evidence. But also, by the way, just one other thing, Diddy gives this man money every month, significant amount of money, his victim. That's what the government's saying. The messages and recordings between Diddy and victim two, on which the government relied at the initial bail hearing, are clear on their face and consistent with the government's representations. The recordings of the calls between victim two and Diddy. He was leveraging, oh my God, this is crazy, y'all. This one took me reading it a couple of times to understand what really is being implied here. The defendant, Diddy, was leveraging significant financial benefits to cause victim two, a man, a purported male victim, according to the government, to adopt Diddy's narrative of their relationship. So basically the government is saying, Your Honor, remember them calls between Diddy and victim two? Yeah, it was Diddy basically, saying something I can imagine along the line. I mean, I don't have any more information than y'all do other than this right here. But I mean, I'm kind of filling in the blanks here. And it's like, ring, 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 ring. Yeah. Okay, this is a recorded call. Who knows? I don't know if it's tapped, who's recording it or what. But here's Diddy. Hey, I'm gonna keep giving you that money if you you remember it the same way as I do, huh? Like you not, yeah, well, because we never was, I mean, you never did anything that you didn't want to, I mean, I thought we was having fun. Like, you know what I mean? Like I can imagine like, something along the lines of that, like, could fit what the government is describing. The recordings, the government relied on these recordings are clear. And they show, according to the government, that Diddy was, quote, leveraging significant financial benefits to cause victim two, this man who he's paying every month, to adopt Diddy's narrative of not just anything, not just any narrative of his innocence, of his freedom. No. Paying him to adopt his narrative of the nature of their relationship. whether he's a victim, like, whoo, they play in chess. Whether or not Diddy agrees with the characterization of victim 2 as a victim, for purposes of this criminal case, the communications highlighted by the government indicate that Diddy used financial coercion to attempt to feed victim 2 a narrative that was consistent with his defense theory, a theory at odds with contemporaneous text messages sent by victim 2 to the defendant and others. Okay. Whoa, 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 whoa. We just got another huge bombshell. I'm reacting to this. I haven't seen this. I haven't read this far by myself. This is crazy. Oh my God. Okay. So I'm trying not to be too like repetitive. I understand like it can kind of feel that way sometimes, but it is important to me that people really understand what's actually going on in the case. There's like a lot of places where you can go and like, oh my God, da, 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 da. And it's like, I watch those channels. I love those channels, but I'm really trying to be like a channel where y'all can actually understand what's going on in the case. So forgive me if it sounds a little bit redundant. I'm trying my best here to make sure that I'm explaining what, to my understanding, is going on. Okay, so whether or not Diddy agrees with the characterization of victim 2 as a victim, the communications, which is like texts or calls, indicate that Diddy used financial coercion to attempt to feed him a narrative that was consistent with his defense theory. So why are they talking about this? It's not just to like drag Diddy. It's not just to say like, oh, slay, hashtag Diddy exposed. No, it's to say there's no circumstance that we could possibly put a set of conditions together where Diddy can be left on bail. There's just no, it's impossible. And a huge reason is because he's interfering with the freaking case itself. Here's an example, Your Honor. This victim, he's using financial coercion against victim 2 to try and get him to not testify in a certain way. That's what's going on here, Your Honor. You cannot let him out of jail. People are saying that's Meek Mill. I don't know who that is. I just saw one. Okay. Let me I do see y'all's chats. Thank y'all so much. I'm gonna keep moving on here. I'll get to those later. Okay. So, Your Honor, also, since we do have a little bit of evidence here, remember the the communications you saw yourself? Yeah. Remember they said the following things, quote, "Diddy just threatened me about my sex tapes where I am heavily DR-ugged and doing things he asked of me." Whoa. Describing, quote, "sexual trauma." Okay. So, Your Honor, yeah, okay. Now that person don't want to be called a victim. Now that person wants to say they were willing. Here, do you remember these text messages that were previously? I don't know if they were redacted or if I just missed them. I could have missed them. There's a lot of documents flying around. The defendant just threatened me about my tapes where I'm heavily drugged and he's doing things. I'm doing things he asked me to do. Remember that, Your Honor? Okay, well, that kind of flies in the face of this guy now saying that he was his best friend or something. Like, that's not what's going on. In light of Diddy's continuing financial support of victim 2, it is not the government, but rather Diddy that is misleading the court. Ooh, mic drop, shots fired. Okay, so basically the whole entire paragraph we just read, the whole point that we just read can be summed up in the last sentence. Diddy tried to say that the government was being misleading to the feds were being misleading to the court because they were saying that this guy was a victim whenever he really was not. And the government's like, oh yeah, did Diddy also tell you that he's paying this guy every month a lot of money? And did he also tell you that it's the same one that he was threatening with the coercion and all of that, and we already told you that evidence? The defendant Diddy's contacts with witnesses demonstrate the threat he poses to the integrity of these proceedings. Okay, so we're still talking about the integrity of the proceedings. The defendant Diddy's attempts to spin his contacts with witnesses, including witnesses served with grand jury subpoenas, as evidence rebutting the government's proof of obstruction, fail. So his arguments are failing. No. For example, the government says, Diddy claims that the government, quote, misled the court and concealed the actual content of the communication between him, Diddy, and this witness who was served with a grand jury subpoena. Okay. So Diddy's like, oh, the government misled you, Your Honor. As an initial matter, the nature and substance of Diddy's communication with witness one was known to the defendant at the time of the initial hearing. Again, we keep coming back to what did Diddy know at the time of that initial hearing, because if it applies to that, then he cannot use it to get now bail, because he already used that before, or he already knew that before the ship has sailed. Okay, so we keep going back to that. Okay, listen to this. Oh my God. More importantly, oh my God, including the fact that Diddy evidently deleted the messages from his phone. The contacts with witnesses confirm the government's proffer at the initial hearing and refute statements made by defense counsel. And remember, they're referring now back to Mark Agnifilo saying, I'm asking you to trust me, Your Honor. I'm asking you to trust me and my client. And the judge did not. The judge put the client in jail. So now the government is saying, okay, that was cute. We let them get that out on the record. Come here, let me show you some stuff that's going to make them look like they lied. Okay. Phone records. We're going to start with the phone records. Show that between the end of 2022 and January of this year, 2024, witness one. So we have three different people we're talking about now. We have victim one, who I believe is Cassie. We have victim two, who I don't know who it is. It's the one Diddy's paying him every month and all that. Now we have witness one. I don't know who this is. But the phone records show that between like the end of 2022 and the beginning of 2024, so basically a little bit over a year, witness one occasionally contacted Diddy by phone and Diddy would not respond. Okay. So for like a year, this guy or girl or someone, witness one, occasionally would try and get in touch with Diddy. Diddy would not answer the phone or respond back or whatever. Okay. That all changed June 2024. Was that the raids? Witness one. Oh, no. Okay. It was okay. What was June 2024? This is when it all changed. When witness one was served with a grand jury subpoena, June 19th, 2024. And after contacting the government, this witness was appointed counsel by the government. Well, the only time that I'm aware of that the government appoints someone counsel is if they too are perhaps being accused of a crime. Why would they be appointed counsel? Who's witness one, y'all? What are the theories? Put them in the chat. Phone records show. Okay. All right. So this is getting good. All right. So we do timelines here. The end of 2022, let's say November 2022, all the way through January 2024. This witness one was trying to get in contact with Diddy. No answer. Then that same year, June 2021, June this year. Witness one, who's been trying to get in contact with Diddy, is served with a grand jury subpoena, contacted the government. I guess that's the next step you have to take, and was appointed counsel. Why? Maybe that's normal. I'm not familiar with grand jury proceedings. Maybe that's normal. Okay. So he did have a lawyer, this person or she. Diddy still initiated contact with that person, which Diddy attempted to obscure by initially calling witness one's wife and then later communicating with witness one over a VoIP service, including by text and by a call lasting over 7 minutes. The following day, phone records indicate, so they're not just telling you to take their word. Well, they kind of are. I mean, but they may have attached it as an exhibit. The following day, that witness spoke with counsel for the defendant, meaning Diddy's lawyer, one of his lawyers. Okay. Wow. Okay. Whoo. Wow. Okay. So Diddy ignores this guy for a year, or girl or person. And then as soon as they get served with the grand jury subpoena, Diddy all of a sudden contacts that person's wife, then later communicated with the person over an obscured voice service by text, not only one time by text, but also a call lasting over 7 minutes. Then the witness talked with Diddy's lawyer. And even though he was represented by a lawyer, he and Diddy continued to directly exchange text messages, and Diddy's lawyer also directly spoke with him again on July 8th, 2024. So the reason this is a big deal is because whenever there's somebody represented by counsel already, this is from what I understand, this from my memory, okay? I think that if you're represented by counsel, like if you have a lawyer and you're on one side, and then somebody else has a lawyer and they're on the other side, and this is criminal or civil, so it would apply to Diddy's case as well as like a defamation claim or something. If the person on the other side that's testifying against your client has or is any way adverse to your client, if the person on the other side has a lawyer and you're the lawyer, like I'm Diddy's lawyer, and that other person has a lawyer and I know it, I have to talk to the lawyer. I cannot talk to, as the lawyer, I cannot talk to somebody else's client. You see what I'm saying? Now, I believe, I could be wrong, I'm doing this as a live. I believe that whenever somebody is a party in the case, now I don't know how the rules might change when somebody is detained, incarcerated, and all that. Okay, so just leaving that to the side. In general, if everyone's free and everyone's their own free will and everyone's walking free and around, I believe that the parties can talk to each other. So I think it is okay for like parties on two sides of a case. Like, let's say like a couple is getting divorced, right? And the wife and the husband need to talk to each other. I think they can. I don't think there's like a rule against it. I don't think it's like, well, you're accused of this or like, you know what I mean? And these are because of the professional rules of conduct, but then also that some criminal and like Brady and like other stuff comes in. But like, for sure, if you are a lawyer, you cannot talk to somebody else, another lawyer's client. You got to talk to the lawyer. You cannot do that. You cannot do that. And that is precisely what's being alleged by the government, the federal government of the United States, is saying that one of these lawyers, I don't know why Agnifilo comes to mind because it could have been any of them. I don't know. He got about 50, 11 lawyers, so I don't know which one it is. But one of his lawyers contacted this guy, even though he or girl or person, I don't know why I think it's a he, even though this person had been represented by counsel. So that's a big deal. That's a big allegation to make because they're making that allegation kind of against Mark Agnifilo I don't know why in my mind it's him. They're making that allegation against one of Diddy's lawyers for sure. And that's a big allegation to make. Like, it's not just the allegation against Diddy. You see what I'm saying? Okay. Even though witness one was represented by a lawyer, he and the defendant Diddy continued to directly exchange text messages. So Diddy kept communicating with this person. I don't know why it matters that this person was represented by counsel. I think for Diddy, it matters more because that he was affecting the outcome of the trial, like a witness thing. Maybe they just put the wrong thing in there. I mean, I really don't know. Defense counsel also spoke directly with witness 1 again on July 8th, 2024. Okay, so the lawyer talked to him again. Following witness 1's testimony in the grand jury in July 2024, Diddy called and texted him again. Okay, so I do think that is a big deal. I think that once you're like accused of like a crime and that person has already testified against you in the grand jury proceeding, like I don't care if it's like your mom, you probably just shouldn't be talking to him from the jail. You know what I mean? It's likely because they say he has a wife. Maybe, yeah, maybe they like, do they call him a he sometime? I don't know. I mean, I'm also used to like talking about Mark Agnifilo as the lawyer in this case. So that would probably explain why I keep thinking it's him, because there are other lawyers. Okay. Diddy's repeated contact with this witness, despite his apparent knowledge that he was represented by counsel and had received a grand jury subpoena, undermines Diddy's lawyer's previous denials of Diddy's interference in the government's grand jury investigation. Okay, so yeah. Diddy and his lawyer like to act like they never did anything wrong and all that. But Your Honor, all of this we just showed you obviously is directly contradicting to anything that they could possibly try to say about that. Like, oh, we didn't interfere. I never interfered, Your Honor. It's like, yeah, right. Look at all this evidence. This concern is amplified by evidence indicating that Diddy appears to have deleted messages with witness 1, although the phone records confirm that Diddy, using a particular phone number, and witness 1 exchanged multiple text messages from June 2024, which is when whenever witness 1 received the grand jury subpoena, June 19th, 2024. And it wasn't until June 19th, 2024, Diddy answers those calls. And look, Your Honor, we have text messages and other communications, phone records that show that Diddy and him were texting, but he deleted the texts. Deleted. Okay. So to wrap up witness 1, okay, we just now went through cool. I don't know why when Kozo Boys just said that, I got chills on the left side of my head and it will not stop. Maybe it's conservatorship or jail hours, girl, but wow, I don't know. I mean, truly, I would not even want to speculate on who these witnesses could be because I have absolutely no context at all, other than like, I don't know what this one filing. Okay. So to wrap up witness 1, we learned from this person that Diddy gives them a lot of money each month, apparently, according to the government's allegation. Diddy apparently, according to the government's allegation, had coerced this person financially on the phone to adopt a certain narrative of their relationship with each other. So yeah, I mean, that's going on with witness 1. Now we're going to move on to witness 2. Okay, so this is now a 4th person we're talking about. We have victim 1 and 2. Now we have witness 1, and now we're about to start witness 2. Diddy also claims that his contacts in September 2024 with an individual represented by counsel who wanted to make a public statement. This is witness 2. So who is witness 2? Okay, here's where you get described who is witness 2. This is our first clue. Okay, a clue. Quote, an individual represented by counsel who wanted to make a public statement. That's witness 2. So Diddy claims that his contacts with that person were not in any way obstructive because the defendant and Diddy because witness 2 and Diddy were previously in frequent contact. Okay. So Diddy and his lawyer are trying to argue, Your Honor, No, we didn't obstruct anything because me and this guy, we go way back and we were previously talking to each other a lot. The government says, however, the contact between the defendant and that witness, okay, they were bandmates. That's interesting. Okay, so we have another clue, a clue. I need to start my little notebook. My notebook's in the other room because I used it to record BJ Investigates yesterday. Okay, so witness 2, I'm just going to start my sticky note on witness 2 here. Witness 2 was a bandmate of Diddy. Bandmate. That is interesting. Who has Diddy been in a band with? Bandmate? Contact between Diddy and witness 2 stopped in March and they were bandmates. Contact stopped March 2024. Okay. All right. They were previously in frequent contact. Okay, but it says, however, all of their contacts stopped in March 2024. And from the timeline and the context of the defendant's contacts with witness 2, it is clear. Okay, this is a big allegation right here. That when Diddy reinitiated contact with witness 2 in September 2024, his purpose was to ensure that witness 2 was on his side and to pressure that witness to make a public statement denying allegations of violence by Diddy. Y'all are just saying names, or y'all have like Usher isn't married. Oh, y'all are speculating Justin Bieber, Boys to Men. Diddy was in Boys to Men though. Dawn, Diddy, Dirty Money. I see. Could be that. We have some more guesses. These are guesses, y'all. I don't know. I wasn't there. Witness 1 could be Farnsworth. And witness 2, Kalina Harper. You say y'all saying Lil Cease, Lil Mace, Young Miami. He wasn't in Boys to Men. That was like Bobby Brown and them. Usher is married, somebody said. Could be. Wow, y'all have some good theories. All right, let me get back to this. Let's get this read first. Or at least, a gist of like what, get my arms around what's all going on in here. Okay. So, all right. So for the timeline purpose, what he's saying is, okay, Your Honor, Diddy's saying, nuh-uh, I wasn't obstructing because me and this person go way back and we used to text all the time. And the government's like, yeah, that's cute. Maybe they texted and then all of their communication stopped in March 2024, whenever Diddy's homes were raided, and no communication happened again till till September. And what happened in September? The indictment. That's when he was finally indicted. And then now the contact all of a sudden started again between these two, witness 2. And Your Honor, the whole purpose that Diddy reached out to this person at all was exactly to interfere with this trial. So he's telling on himself, hello. Also, he was pressuring this witness to make a public statement denying allegations of violence by the defendant. He reached out to this witness on September 11th, 2024. So this was, I think, before the indictment. Didn't the indictment happen on September 12th? Hold on. When was this indictment? Did he know he was getting indicted the next day? I think they knew. He knew he was getting indicted the next day because he had expected to get arrested the next day. I remember now. Okay. Her. Okay, we got it. Witness 2 is a she. Okay, we got another clue. Witness 2 is a she. Okay. The defendant reached out to witness 2, so that lends credibility or some veracity, I should say, to the idea that it could be Kalina Harper because she would be a she. Wow. Wait, this is Dawn Richard. Maybe it is Kalina. Yeah, okay, this has to be Kalina, in my opinion. I mean, I don't know, I wasn't there, but I think this lines up with the other lawsuits. I'm having a little galaxy brain. I don't wanna explain it right now, but maybe we can later. Okay, so it doesn't matter. We'll just keep saying witness 2, who's a woman and who was in a band with Diddy. The defendant reached out to witness 2, September 11th, 2024, this year, just 2, 3 months ago. Sent her a copy of a lawsuit against Diddy in which this person's name was mentioned several times. So it's like, witness two's name is right there in the lawsuit. And here's Diddy sending her a copy of it going, look at this lawsuit. He then called her. He called her up. They spoke for nearly 6 minutes. After reading the lawsuit, witness 2, okay, so after reading the lawsuit, okay. So Diddy sends her this lawsuit, according to the government. She reads it. They talk on the phone 6 minutes. She reads the lawsuit. She calls him back. At his request, he had asked her to call him back. Hey, go read it and call me back. And then they spoke for more than 4 minutes. Evidently, Diddy and witness 2 discussed witness 2 drafting a statement. Y'all want to talk about people getting approached to draft statements, false statements? Because I have some firsthand experience. Some people did that to me. Both of them have now reneged. Yes, legal fund linked below if you'd like to donate to that. Evidently, the defendant and witness 2 discussed witness 2 drafting a statement as immediately after the call. Defendant 2 told witness in a text message, redacted. Okay, so witness 2, okay, they get on the phone. Okay, so this person gets on the phone, calls Diddy. Hey, I just read the lawsuit. They talked about this person writing a statement. And then there's this text message that Diddy sends to the person about conceivably something about writing a statement is redacted. The defendant then asked witness 2 for her attorney's name, From September 11th through September 15th, 2024, so that's like 3-4 days, Diddy and witness 2 exchanged multiple texts and had multiple calls, at least 128 phone contacts in total. Throughout these phone contacts, the defendant, Diddy, repeatedly asked witness 2 when she planned to post her statement. Okay, so Diddy's lawyers brought this call up and said that this was another instance of like this person was reaching out to Diddy and it wasn't like he was harassing this person or something. And the government's like, that's not the freaking point. Diddy keeps thinking that these people are like victims that are accusing him. No, accuser and victim is not the same thing. You might have been reaching out to somebody and conspiring with them, and they might have still been a victim, or maybe they weren't. Maybe they're just a witness. And then the question becomes, why are you having 128 freaking phone contacts with a witness, whether they're a victim or not? It's questions needs answers. I agree. Throughout these phone contacts, Diddy repeatedly asked witness 2, that's whoever this person is, when she was going to post her statement, her public statement. Then a bunch is redacted. Witness 2 ultimately made a statement about the lawsuit via an Instagram post. Oh, who is this, y'all? Where's the Instagram post? Then after the defendant, Diddy, was in custody, the Bureau of Prison Investigators recovered the following notes. Oh my God. I cannot believe they just put this out here like this and like we get to just read it like this. I mean, oh my God, we the news now. I mean, with opinion attached, of course. Y'all, please. We're getting told that they did actually find stuff in Diddy's cell. Look. The Bureau of Prison Investigators recovered the following notes from Diddy's cell during a pre-planned nationwide sweep of the facilities. And remember, he was so mad that they came through and rifled through his stuff. Oh my God. I'm calling it right now. I'm calling it right now. Put your money on Diddy's going to say that they planted evidence in his cell during these things. I mean, I don't know. It's just a psychic vision. Throughout these phone contacts, Diddy keeps asking this lady when she's going to post her statement. She posts it on September 13th. But then after he was arrested and in custody, then the investigators recovered the following notes from his cell during a sweep. And I don't know what the notes say because they got a big black block right here, as you can see. The strong inference, so they're going to draw an inference for us. The strong inference to be drawn from Diddy's communications with witness 2 and from his personal notes is that Diddy paid witness 2 after she posted her statement. Y'all, this is witness 1 getting paid off, just in case you're keeping your notes. This is allegations from the government. We're talking about 4 separate people here, okay? Victim 1, Cassie, we think. Victim 2, witness 1, who is a man who's being called a victim by the government, but Diddy's taking issue with it. It's like, no, that wasn't a victim. That was something else. We had a mutual consensual relationship. It was consenting adults. And then this person apparently has text messages where they're describing the sexual trauma. Diddy's coercing them. Diddy's paying this person every month. Witness 1. No, victim 1. Shoot, I got them confused. Hold on. Let me get them straight because if I don't understand it, how y'all gonna understand it? Hold on. Victim 1. That's why I started keeping my note. Victim 1 is presumably Cassie. That's what I think. Yes. Victim 2 is an individual who the defendant continues to pay a significant monthly sum. Then we got witness 1. Who is the one that Diddy didn't talk to this person for like a whole year and then or respond to them. But then after the person got the grand jury subpoena, witness 1 in June, then that's when Diddy started contacting them. And it was clear, according to the government, that the whole reason for Diddy contacting this witness 1 at all was to pressure them. The lawyer talked to him. Okay, then we got witness 2. The defendant also claims that the contacts, and this person is an individual represented by counsel who wanted to make a public statement. They were bandmates. This witness 2, the one that was his bandmate. His purpose, according to the government, was to ensure that witness 2 was on his side. They talked 138 times. She was going to make a statement, and the government is saying right here, you heard it here first, maybe you heard it here 4th, 5th, 7th. They are saying that witness 2 was also paid to make that public Instagram statement. So this is 2 separate people they're alleging were paid specifically to put a public narrative out. After he was in prison, jail. From the timeline, the context, and the content, Diddy's clear goal was for witness 2 to draft and post a statement. Even after Diddy knew witness 2 had a lawyer, he continued to reach out to her directly, a fact that clearly concerned Judge Carter. So Judge Carter had an issue with that, and rightfully so, they say. That Diddy had multiple phone contacts with witness 2 up to and including March 2024 changes nothing about the damning timeline and content of the calls in September 2024. These communications are another example of Diddy using manipulation, influence, and power to persuade witnesses to support him. And why do we care about that? Because there's no set of conditions that will stop him from doing that. We need to have a fair trial, and look what he's doing. Oh my God. Look at this footnote about the stuff that they found in the prison. With respect to materials received from the Bureau of Prisons that included possibly privileged materials, such as the notes recovered from Diddy's cell, the prosecution team only accessed those materials after they had been reviewed by the filter team. Okay, so they're saying, look, we passed it through the right filters and all that, so don't come at us for Brady or something. Based on the foregoing, Diddy has not demonstrated that he's entitled to reopen the bail hearing under the Bail Reform Act. And he doesn't provide any good case law to support his point. His reliance on this other case is misleading. No, it doesn't matter. This is just a little technicality stuff about that specific case. Okay. Alternatively, other than him just wanting straight up bail, he wants to get let out because he thinks it's not fair that he has no access to a pen and something or the other or whatever, right? Claiming that Diddy cannot adequately prepare his defense. The law does not support his release under this provision. He can't get out on that either. He ain't getting out on bail and he ain't getting out on temporary. Boo-hoo. Too bad, so sad. He's been provided with more than reasonable accommodations to meet with his lawyers. He's permitted to meet with him 7 days a week and regularly has access to a separate conference room off the common area of his unit. Okay. Well, I'll tell you one thing. When Diddy was asking for his bail, he didn't say that part. I mean, that makes a big difference, in my opinion, to me, right? Like, he's permitted to meet with his lawyer 7 days a week and regularly has access to a separate conference room off the common area of his unit. In fact, records indicate that Diddy has met with his lawyer most days since he's been in custody. Records also indicate that Diddy frequently communicates with his lawyers by telephone and written communication, including, as explained below, through unauthorized means. Y'all. Oh my God. They're saying he communicates not only with everybody else, but with his lawyer through unauthorized means. Even if the defendant were only using authorized channels of communication, the prison's procedures do not, or sorry, jail's procedure, it's a detention center. The detention center's procedures do not infringe on his rights to effective counsel or to participate in his trial. So he needs to just get over it. Second of all, the lawyer's proposal that Diddy has to be released in order to prepare for his defense is inconsistent with the Bail Reform Act, which contemplates that courts will weigh dangerousness and risk of flight against the defendant's opportunity. Okay, so more of the same. Then Diddy cries and whines about there's the 11 terabytes of data or whatever. That is not a basis for letting somebody out under anything, for any purpose. The defendant Diddy does not point to any case law suggesting that discovery of the kind produced in this case requires his release. While the Bail Reform Act does not mandate that he gets released, even if it would be, okay, just because it would be more convenient for Diddy outside of the jail doesn't mean he has to get out of jail. Especially because he's a danger to society, is the argument. Finally, Diddy complains about conditions at the jail. Oh, sorry. Excuse me. Finally, Diddy's complaints about the conditions at the Metropolitan Detention Center come as a surprise to the government, given the contrary public statements made by Diddy's lawyer and statements made by defendant on monitored calls. Oh my God, y'all, they're already using his monitored calls from inside the jail against him. Beep, beep, boop, boop, wee, wee, woo, woo. You heard it here first. Maybe you heard it here 40th or whatever. Y'all, this is the first time I'm seeing it. Diddy. Oh my God. Okay, so he complains about conditions inside the jail, but that ain't what he was saying on the phone. That ain't what his lawyer said to the news. That's basically what this sentence is trying to say. Additionally, his lawyer has made no attempt to confer with the government about their concerns. Okay, we got to get to this footnote. The defendant's complaint that he still does not have a laptop is overstated. At defense counsel's request, the government prioritized production of the defendant's electronic devices, which the defendant is not entitled to keep at the prison due to their designation as attorney possession only. The bulk of the materials that Diddy is entitled to keep at the jail were only produced recently, and immediately following their production, the government began preloading the defendant's laptop and expects to. Okay, so they're saying he's like overblowing the whole laptop thing too. For the reasons discussed above, Diddy has not met his burden of demonstrating that he's entitled to even get a hearing. Okay, much less once we get to the hearing stage, then we can argue about what's going to happen there. Accordingly, the court does not need to make a determination regarding Diddy's flight risk or his dangerousness risk. However, even if the court did finally make it past that hearing stage, even once we get there, he's going to fail and he's going to flop. The detention has to remain because, again, we're going to keep coming back to this. No condition or combination of conditions can assure the defendant's appearance and the safety of the community, nor can conditions prevent the defendant's continued obstruction efforts. The incorporated submissions and arguments presented to the judges support these findings. So they're saying we have evidence, Your Honor, please. You saw it. We all saw it. We all know it. We all have seen it. The defendant, Diddy, has continued his efforts to obstruct justice. And I fear this may be the moment we've really been waiting for. Okay. Here comes the new. I mean, we got some new, but I think this is like the new section. Oh, okay. Off the bat, we get a footnote. The defendant has continued his efforts to obstruct justice. Footnote 7. Okay. See that? What is footnote 7? First of all, redacted. 6 is redacted. Where's 6? Yeah, okay. Look at that. Okay, so 6. Oh my God, this is crazy. Exhibit F. So it's redacted exhibit, okay? But there was an October 27th phone call. So a phone call in jail. Oh my God, y'all. Okay, there was a phone call in jail like just a couple weeks ago, in which Diddy describes the center, okay, but they redact it. Now we're at footnote 7, and it says, since Diddy's arrest, the government has continued investigating his obstructive conduct and began receiving recordings of his prison calls in last month. Oh my God, y'all. The government, the feds have been getting Diddy's recorded calls, which we all knew they would get. They can request or whatever, but we didn't know when or where or how or what they do have and don't have. They started getting them last month. They said these calls in their entirety will be produced to Diddy through a filter team prior to the bail hearing, which is scheduled for the 22nd, which is, I have it written down. It's this Friday. So in 6 days, there's a bail hearing. So they're saying before the bail hearing, the one we're reading this document for right now, right? The hearing, it's coming up Friday. It's Friday. Okay. This coming Friday. And the government's been getting Diddy's calls from prison. I think or jail or whatever, they got all of them. They got it or began receiving them last month. And the calls are going to be entirely produced to Diddy sometime this week. Like, it could have already happened. And to Diddy means to his lawyer, obviously, or his lawyers. Wow. The government did not previously disclose these recordings. This is coming as a surprise. I think Diddy's learning about this at the same time as pretty much us. I mean, he might have got it. I mean, we might have learned about it before him, truly. The government did not previously disclose the recordings. They were getting his calls from the jail and never told anybody. They just been sitting and listening. Oh my God, please. The government did not previously disclose these recordings due to its ongoing investigation, but is doing so now. Given the recent escalation in Diddy's efforts to influence the jury pool in this criminal case, set out in more detail below. Oh my God. To the extent there was any doubt about Diddy's risk of obstruction at the time of the prior bail hearings, such doubt is now non existent because Diddy, since he has been detained over there at the MDC, he has continued. Since he's been in jail, he has continued to try to evade law enforcement monitoring. He has been corruptly, oh my God, this is insane. This feels like historical that we're just like reading this on a Saturday night at 9 p.m. Like, what? There's 3,900 people in the chat. Ooh. Since Diddy's been in jail, he's been trying to evade law enforcement monitoring. He's been corruptly, quote, influencing witness testimony and further attacking the integrity of these proceedings. Specifically, while in custody, he has repeatedly communicated with others in ways that violate the prison rules and are designed to evade prison and law enforcement monitoring. Oh my God. Including, as described below, using PAC numbers belonging to other inmates to make calls. Okay. So they're saying, Your Honor, we're going to tell you how he's doing all this stuff, but just give you a little preview, a little roadmap. All that stuff we already told you was bad enough. All that was information we all already knew. I don't know why we having to keep rehashing this and going over it over and over again. But okay, put that whole chunk, put Act 1 aside. Okay. Because actually, the last thing Diddy should actually want, Your Honor, is to go back in front of you on this question because we got all his prison calls now and some other stuff. And we'd like to actually tell you, definitely lock him up and throw away the key because the man is acting a little bit out of control, even all the way still in jail. What is he doing in there? They are alleging. Generally, he's trying to escape law enforcement monitoring, for one. And two, he is trying to intimidate or otherwise influence jurors and the outcome of this case, both in court and publicly. Okay. Specifically, what he's doing from inside that jail, he's using other inmates' call home number so that, I guess in his mind, he doesn't think it's going to be able to be traced back to him. But in his defense, he may try and argue, his lawyer may try and argue, he ran out of minutes and he needed to, whatever. And, he was waiting for somebody to fill his minutes up and it was an emergency. I mean, they have no shortage of excuses when they get busted. What else is he doing from inside that jail, according to the government? Making three-way calls. So he'll call one person and then that person will get on the phone. Like, okay, like he calls his daughter or whatever, his son or somebody or whatever, right? And it's like, okay, call such and such. And so now they're on a three-way call. So the government's saying, yeah, you're not slick. We got the three-way calls, so we know you've been doing it. Stupid. Also, it ain't just anybody. It ain't just his wife and his kid or whoever, his kids and his loved ones and his approved contacts. No. He been talking to people on three-way, not approved, not approved. And as if that's not enough, contacting even some of those people, the unauthorized ones, on an unauthorized third-party communication system to send messages to numerous individuals. Okay, what's 8 say? Oh my God. Okay, so footnote 8 is explaining, in case we don't know, which I don't, how it works. It says when an inmate enters federal custody, he is generally permitted to communicate with out-of-custody individuals, including friends and family members. To do so, inmates provide a contact list. So you tell them who you want to talk to. I want to talk to my mom, I want to talk to my kids, whatever. My lawyer, everybody else. That includes the individual's name, phone number, and email address. The Bureau of Prison staff must approve individuals on a contact list. Okay, so it's not just, you can't just put any and everybody on there. The staff has to approve them. Okay. To ensure that the messages do not jeopardize the public safety, security, or orderly operation of the facility. When inmates make telephone calls, they are required to use a PAC number or a phone access code. That number is connected to their unique Bureau of Prisons register number. Inmates access email using the True Links system, which is operated by a company called Core Links. True Links is a fee-based system that inmates must pay for to send or receive email. Okay, so if you want to send email, you need True Links. Okay, and True Links company that owns it is called Core Links. Okay, so you can't just be calling and emailing any and everybody. All right, you can't. You got to have them on their list. All right. So first, they're going to get into this using the other inmates' phone access numbers. Oh my God, this is crazy, y'all. Whoo. This was filed yesterday at like 11 o'clock at night. Like not even 24 hours ago, this thing was filed. And today is Saturday. They are crazy for that. Like 12, like almost midnight on a Friday, they filed this. The government has reviewed dozens of recordings of Bureau of Prison jail calls in which Diddy uses telephone accounts of at least 8 other inmates, which is against Bureau of Prison regulation. Seemingly, he's doing this to avoid law enforcement monitoring. Oh my God, they busted his behind. Wow, busted. Diddy uses other inmates' phone access numbers to make phone calls to both individuals on his approved contact list as well as other individuals who are not on the approved contact list. To obtain or maintain access to other inmates' phone access code numbers, he directs others to pay them. Oh my God, he is running a scheme and a scam according to the government's filing that we are looking at on the screen right now. 4,000 in the chat. Shout out to y'all. Oh my God, they said to obtain or maintain access to other inmates' numbers, Diddy, from inside the prison, directs others to pay the inmates for the use of their numbers, including through payment processing apps. That sounds familiar to, I'll keep that to myself for a moment. Okay. Also, he'll have stuff put into their commissary account. So it's like, let me use your minutes and I'll have money put into your commissary. Diddy knows this is against Bureau of Prison regulations. Oh my God. Y'all, this is crazy. At the outset of each telephone call, any person using this system is prompted to enter his number, after which an automated recording announces, quote, sharing of personal access code numbers is against Bureau of Prison policy and is subject to disciplinary action. So every time Diddy has done this, allegedly, I don't know if he did it, I wasn't there. The government's saying he did do it. He's got to sit there and listen to the speaker go, quote, sharing of PAC numbers is against BOP policy and is subject to disciplinary action. Every time he gets on the phone, he hears that. And still out here, he is doing it, they saying. All right, so now they're going to talk about the three-way calling. The government says the defendant also frequently instructs individuals who he contacts by telephone, including family members and his attorneys, to add other individuals onto three-way calls. So he'll call his family member or he'll call his lawyer and they'll add somebody to the call. This practice is not authorized. It's another one, right? Also not authorized by the Bureau of Prisons, as it helps conceal the identities of the contacted individuals. So why is this important? Well, because it shows that he is in some way, according to the government, trying to tamper and conceal the identities of these people contacted, makes it harder to keep up with. He's just a slippery snake out here. The government has reviewed multiple calls. Oh my God, y'all. The government has reviewed multiple calls in which Diddy instructed others to dial in third parties, including members and associates of the enterprise, his co-conspirators, alleged, and individuals who are not on his contact list. Okay, now they're going to talk about the non-authorized messaging services. In addition to breaking all these Bureau of Prison rules regarding phone use, Diddy also uses a non-authorized third-party messaging service called Contact Me ASAP to obscure his communications. We got another footnote, y'all. Footnotes are on fire. Let's go see. According to the Contact Me ASAP website, the service purports to be a um, quote, an innovative text messaging service for federal inmates to communicate with loved ones via real time messages, and claims to offer seamless SMS conversation. Contact Me ASAP provides an email address for the inmate, which is then put on the inmate's Trueling's computer. And from there, the inmate can immediately use the service to text contacts. Okay. Seems fine. What's wrong with that? Oh, it's not authorized. Okay. Okay. So what's wrong with it is, yeah, that's all fine and good, but that's not authorized. I don't know why he's using that. It's not authorized. And he's doing it to obscure his connections. So, I'm sorry, his communications. So not only is he trying to obscure it through doing these third party three-way calls, call so and so, trying to obscure. He's also using other people's prison number, access code number, phone access code numbers, trying to obscure. He's also using Contact Me ASAP, trying to obscure. And you trying to let him out? Please. Oh, I meant to do that. First, oh shoot, Diddy appears to be using two of these accounts. First, oh my God. Okay. This is scathing. Okay. First, Diddy's Bureau of Prison contact list includes a particular email address assigned to Diddy's son. Okay, so his son has an email address. One of his son's email address, got it. That's on the list. This does not appear to be an account owned by Diddy's son, but instead, it appears to be an email address connected to Contact Me ASAP. So I don't know if they're trying to say he's lying, like, is that Lou Taylor and they saying it's the son? Because they looked up the email address and it's a Contact Me ASAP email address. And they're saying that it looks like it's not owned by the son. Second of all, the filing goes on. Diddy appears to be using another inmate's Contact Me ASAP account, primarily using email one. Diddy has exchanged hundreds of text messages with dozens of individuals, including attorneys and individuals who are not on his contact list. So he has sent and received hundreds of text messages. They letting them text in the prisons, y'all. Or is it you can make it into okay. So it's like emails and turn them into text or something. I don't understand what the big problem is. I mean, I do understand the problem if he has two accounts and using it to obscure. That I understand how that is a problem. Appears to be using another inmate's Contact Me ASAP account. Using email one, Diddy has exchanged hundreds of text messages with dozens of individuals, including people that are not on his approved contact list. His repeated circumvention of the Bureau of Prison regulations, starting almost immediately after, oh my God. So he's been breaking the rules starting pretty much as soon as he got here at the detention center. And it says it speaks volumes about his ability to comply with any conditions of release. Even more, oh my God. Even more concerning, however, is Diddy's use of these unauthorized methods of communications to continue his efforts to obstruct and subvert this criminal proceeding. His intentions are reflected in his own words on Bureau of Prison calls, y'all. And if you're just getting here, or if you maybe forgot, we are learning in this filing right now, and it was filed less than 24 hours ago, that the government has been receiving prison phone calls of Diddy's since last month. And Diddy did not know that. Nobody knew that on that side of things. And the government's like, oh, we kept it a secret because whatever their reasons were or whatever. To obstruct. Yeah. This is crazy. They're telling us, they're like, imagine you're Diddy's lawyer, you're Diddy, and you're like they're so busted. And it's just like, here you go. You thought, contact me ASAP. No, we got you. We caught you. Oh, you thought somebody, a three-way call? No, we got that too. And it's recorded and we have your lawyer. It's like, It says the defendant Diddy's intentions are reflected in his own words on Bureau of Prison calls with a network of family members and associates who Diddy has tasked. Oh my God. I did my Lou Taylor antenna is tingling. I don't know why. I'm feeling like Lima is somehow, no, you started with the last star. Oh my God. Diddy's intentions are reflected in his own words of call on calls with a network of family members and associates who Diddy has tasked with executing his will on multiple calls, often using other inmates, other people's phone access numbers. Diddy is explicit about his intention to use public statements to alter public perception. Oh my God. Who was in here saying, do I think Diddy was funding Big Joe's lawsuit? I didn't think that, but now I'm like, wait, public statements to alter public perception? A big public statement you can make is a lawsuit, you know? Diddy leaves no doubt. Well, I don't know what's redacted, right? On multiple calls, it says, often using the phone access code numbers of other inmates. Diddy is explicit about his intention to use public statements to alter public perception and blank. I don't know what it says. But then it goes on. Diddy leaves no doubt that the narrative he wants to blank is the potential jury pool's perception of this criminal proceeding. I don't know, maybe change. I don't know, flip. I don't know what your guess is as good as mine. Take a guess in the comments down below. The defendant leaves no doubt that the narrative he wants to blank is the jury pool's perception of this criminal proceeding. Okay. I think that, oh man. I have a psychic vision. I'm going to make, okay, hold on. I'm going to make a members only psychic vision. Because I want to say this to my friends, but I don't want to say it like to everybody. Okay. Examples of these efforts are plentiful. Okay. Notably, Diddy continued these efforts after the court's October 25th order, which was requested by him, prohibiting exactly this sort of conduct. Ooh, another mic drop moment, a little legal mic drop, as it were. They're like, you remember all the belly aching he was doing about a gag order this, a gag order that, a don't contact this, a don't contact that. Well, that's all fine and good. Tell me why he broke his own gag order then. He kept doing all this stuff. He was asking us not to do things. Look at him. Oh my God, this is crazy. I cannot believe I'm reading this in a public legal filing. After the court entered the order, it says, quote, Diddy, quote, enlisted family members to plan and execute. This is so embarrassing. Oh my God, y'all. They have calls. They have phone calls. They're saying, Your Honor, we have a phone call of this idiot after he requested a gag order. He is enlisting his family members to plan and execute a social media campaign around his birthday with the intention of influencing the potential jury in his criminal proceeding. At the defendant's carefully curated direction, his kids posted a video to their social media accounts showing his kids gathered to celebrate his birthday. And we watched it. We reacted to it over here. I have a video on it. Go watch it. Diddy, from within the jail, then monitored the analytics. Holy sh! This is insane. It's because I know this is what they do, and I've been saying it for like 4 years, and I've been called everything but a child of God, including a child of God, actually. But I know this is what they are doing, but I have been so gaslit for 4 years at this point, and hundreds, thousands of y'all in the chat have as well. It's like, oh, now we're just putting it black and white, clear as day in the filings in the criminal case. Good. Good. Duh. Lou Taylor, you're on deck, buddy. Diddy, from within the detention center, monitored the analytics of the birthday party video, like the audience engagement numbers, and he explicitly discussed with his family how to ensure that the video had its desired effect on potential jury members in this case. And then they black out a whole bunch. But look, I mean, this is a call. November 4th, 2024 is his birthday. Okay, so they're citing a call from his birthday, Exhibit J. Who, besides flagrantly violating the court's October 25th, 2024 order prohibiting this kind of interference with a fair trial, Diddy's own words make clear that his intent is to improperly influence the jury pool in this criminal proceeding. Diddy does not stop there. During other calls, he makes clear his intention to anonymously publish information that he thinks will help. Oh my God. During calls, Diddy makes clear his intention to anonymously publish information that he thinks will help his defense. What? What? On the jail. I thought every idiot knows that if you're talking on the jail phone, you're getting recorded. His efforts to anonymously leak video favorable to his defense in this case show that he is using his so-called public relations strategy, and they put that in quotes. I wonder if that was one of those redacted things behind the redacted wall. Oh my God. It shows that he is using his public relations strategy to influence this criminal case. I have a strong feeling that he's calling someone a public relations manager, public relations strategist, and it's not. It's like interfering with a fair trial strategist. But here's what's going on. I can speculate, okay? In Britney Spears' case, and this is relevant because we have the same management team involved, which means they probably have similar PR strategies built in, okay? And this manager has been with Diddy, or at least knowing him since the early 90s, like 30 years, okay? So this woman was in charge of Britney Spears' conservatorship, the finances, as far as I can tell. And this is Diddy's business manager, okay? Last I checked, last I heard. Well, in Britney's case, after Lou Taylor, the business manager, had not been on the case anymore, but at some point, it became public that Jamie Spears, Britney's dad, had charged Britney's estate $500,000 in a line item on the accounting called Media Matters. And Britney Spears' lawyer took a big issue with the Media Matters section. He's like, we're not paying that out of my client's estate. They wanted $500,000 from Britney for the Media Matters for the conservatorship. And the Media Matters was lawyers going on national television. The Media Matters was shaping the media narrative about Britney Spears' conservatorship. Okay. So I find that what I just told y'all an interesting point whenever you take into consideration all of this crap that's redacted. We don't know what they say in behind these black bars. All right. But we had this in quotes. Why? It's probably referencing something. Why are they quoting this? We don't know. We don't know. Diddy's efforts to anonymously leak favorable video to his defense in this case shows that he is using his so-called, right? Who called it that? I don't know. I think he called it that. It's a clue. Quote, public relations strategy to influence this criminal case. Diddy's effort to obstruct the integrity of this proceeding also includes relentless efforts to contact potential witnesses, including victims of his abuse. Contacting witnesses, including victims of his abuse, quote. who could provide powerful testimony against him. They give an example on October 4th, 2024, in a call involving Diddy and one of his adult sons. Diddy says the following, redacted. And what's crazy is probably Diddy don't even know yet. You know what I mean? Like, it's just redacted. Like, shit, what did I tell him? Look at all this. Wow. So we have another inference here they're making after all that redacted. This provides the clear inference, quote, that the defendant's goal is to blackmail victims and witnesses. Whoa. Defendant's goal is to blackmail victims and witnesses either into silence or providing testimony helpful to his defense. Whoa. So this right here is allegedly, supposedly inferring or helping them to infer that Diddy has a goal to blackmail people and threaten them into silence. Wow. In addition to failing to, the defendant is a danger to others. So this is a whole entire other issue. He's actually just a deranged animal that is dangerous to people, according to, paraphrasing here. In addition to failing to meaningfully contend with the ongoing risk of obstruction that Diddy poses, he also spends pretty much no time addressing the significant acts of physical violence that the government highlighted at the initial hearing. You remember the one that led Judge Carter to conclude that Diddy is a danger to the safety of others in the community more generally? Remember that? Diddy doesn't spend any time at all trying to argue about that. Indeed, as the record before this court makes very clear, Diddy's long history of violence demonstrates his dangerousness. Moreover, contrary to his claim that the evidence is thin, evidence supporting Diddy's long history of abuse, including witness testimony, communications, photos, videos, police reports, and other materials, demonstrates the strength of the government's case against the defendant, a factor considered by the court. Okay. Okay. So basically they're saying they disagree with Diddy, that Diddy said the evidence was thin. They're like, no, it's definitely not. As charged in the indictment, Diddy has engaged in physical, sexual, and emotional abuse of his romantic partners for years. He also engaged in acts of violence directed toward his employees and many others, including kidnapping, arson, and physical violence, such as throwing objects at people, throwing people to the ground, hitting, kicking, dragging, choking, stomping on, and shoving others. Multiple witnesses, including Diddy's employees and others, observed or experienced the defendant's violence firsthand. His acts of violence show there is no condition. Again, this is what they have to prove. There is no condition, right? Because they have to argue this Bail Reform Act or combination of conditions that will adequately safeguard others. The judge transcript they're quoting here. The danger, I think, is quite serious. Quote, there have been weapons around. There's been significant violence. And I also think it's significant that there has, I think, been a proffer of significant evidence of coercion of witnesses. The judge said in the transcript, I also find that the government has proven that the defendant is a danger to the safety of others. So Diddy is a danger to the safety of others. The judge found it already. Far from the only example, the video from the, hotel incident at the Intercontinental Hotel, discussed at length in all these proceedings, puts Diddy's dangerousness on full display. Although his lawyer conceded that the incident was relevant to the determination of dangerousness, he fails to address it with respect to the present motion. Instead, he just repeats his prior characterization of his relationship with victim one as complex. That's Cassie. And at times toxic. Okay, well, good, great. But that's already been said, Your Honor. That's not new, is what they're kind of arguing. It pivots to the defendant's philanthropic endeavors and family relationships. It's just an effort to distract. His personal relationships and charity work does not neutralize or erase. Yeah, so what? He's an altar boy. Who gives a crap? He was an altar boy and he went to the Catholic school. I got news for him about what some of them bishops were doing or whatever, if you know what I mean. But the defendant's personal relationships and charity work does not neutralize or erase the video evidence showing him punching Cassie, dragging her, throwing a vase at her, and kicking her. In sum, Diddy cannot walk away from the clear record in this case. His inability to explain away his long history of violence, including that incident in the hotel captured on film, is a fatal blow to his application for release. His extensive history of violence makes him a danger to those around him, and the safety of the community cannot be ensured short of his continued detention. He's just a dangerous, violent animal, Your Honor, is what they're trying to argue. Okay, that's interesting. Noting a willingness to strike loved ones offers probative evidence of a tendency to violence. Okay, so they're saying, look, Your Honor, this other court in Mercedes already found that a quote willingness to strike one's loved ones offers probative evidence into somebody's tendency for violence and dangerous toward others. Like if you'll hit your loved one, you're a violent criminal, is what they're trying to basically say, or you're a violent person, innocent until proven guilty, not a criminal. The defendant has not rebutted the presumption. Okay, so then they're like, okay, oh yeah, that one last thing, one more thing, Your Honor. He's also a flight risk, and he doesn't do anything to argue that he's not. He has not rebutted the presumption that there's no conditions to assure his future appearance, given the fact that he faces mandatory minimum sentence of 15 years imprisonment and a statutory maximum of up to life. He might be facing up to life. He could go to jail for life. In this case, Diddy has incentive to flee. Given the potential punishment and the nature of the evidence that will be presented at trial, he has nearly limitless resources to facilitate his flight. While counsel took steps to mitigate his substantial risk of flight before the indictment, his incentives have materially changed now that he faces the very real possibility of a substantial term of incarceration. So they're saying, yeah, before he wasn't as much of a flight risk because he wasn't like indicted and in jail, but now, oh, he's much more of a risk because his incentives have changed. Then they say his new proposed bail package that they're finally going to address here is insufficient. In the face of the significant evidence that the defendant poses a risk of obstruction, he's also a danger to the community. He's also a flight risk. His proposed updated bail package is woefully insufficient. As discussed, Diddy has shown repeatedly, even while in custody, that he will flagrantly and repeatedly flout rules in order to improperly impact the outcome of his case. He has shown, in other words, he cannot be trusted to abide by rules or conditions. While the proposed conditions suggest that Diddy will have no access to telephones or the internet except for calls with counsel, this is insufficient to ensure that Diddy will cease engaging in unauthorized or inappropriate communications through third parties because he's already doing it in the jail, they're saying. They said he's already doing just that against the Bureau of Prison Regulations. If the defendant cannot abide by rules in the highly restrictive setting, oh, this is the strongest sentence of the whole pair. This is the strongest sentence of the whole 24 pages. If Diddy cannot abide by the rules in the highly restrictive setting at the Metropolitan Detention Center, there is no reason he should be trusted to abide by the courts. Whoo! And because that's going to be even less restrictive setting. Furthermore, Diddy's proposal to restrict visitors to select family members is also insufficient. Why? Because Diddy was like, oh, look, only people are going to come are like certain family members. Not that either, buddy. Why? Quote, since being in custody, Diddy has deployed family members to carry out obstructive conduct on his behalf. Oh my God, this is crazy. As evidenced in these just now learned about jail calls, Diddy asks family members to reach out to potential victims and witnesses. He asks family members to create, quote, narratives to influence the jury pool and to pursue marketing strategies. Oh my God. Jesus Christ. This is damning. And that's why I titled this video, Diddy's Problems Just Got 1,000 times worse, or 10,000, or however many zeros I put. Could have been 100. I don't know. It's like just blow after blow after blow. Each one is bad enough alone. The jail calls getting released. He's asking family members, Your Honor, my family members will co-sign for me. They'll co-sign, they'll guarantee. You're asking those same freaking family members to reach out to victims, potential victims, witnesses, to create narratives to influence the trial and to pursue marketing strategies to influence public opinion. Diddy's emphasis, they go on to say, on 24/7 private security is also problematic. Yeah, because I was like, who's going to hire them? Who are they going to work for? Diddy has demonstrated an uncanny ability to get others to do his bidding. Employees, family members, and inmates alike. There's no reason to believe private security personnel would be immune. Yeah, you're paying them, especially. This court is troubled by the possibility of allowing wealthy defendants to buy their way out by constructing a private jail. He's quoting a prior ruling. At any rate, the defendant's private jail proposal, at best, elaborately replicates a detention facility without the confidence of security such a facility instills. Yeah, so basically what, you want to create your own little jail at home, but the prison guards are the people you pay? No. Moreover, the Second Circuit has expressly decreed attempts like the defendant's to pay his way out of detention. His updated proposal simply does not alleviate the risk of danger, obstruction, and flight, particularly in light of his inability to comply with the prison regulations and his efforts to engage in obstruction, even while subject to being monitored at the detention center. So how you going to look letting him out? For the reasons above, deny his bail. Thank you. Exhibit A is what? Letter to the judge, the first bail letter. I mean, a lot of these are, oh, we saw that already. A lot of these are, redacted. I'm just kind of scrolling through. Exhibit B. It's like, wait. Oh yeah, that was the bail letter. So, I mean, let's go up to the, actually, let's go to the table of contents because then that'll just tell us what the exhibits are. Can you give us an exhibit list? Please. They're wrong for that. Okay. Well, I don't want to just sit here scrolling quietly. So I'll take a look through these exhibits. I mean, there's some bombshells in here, y'all. I think the biggest one to me, just like sitting here, you know, like way past my bedtime at nighttime, the prison calls they've been getting and been having. The fact that Mark Agnifilo asked the judge, told the judge, trust him, trust his client. It's silly. The adult son, the family member thing, it's like he's having his family members co-sign for him on this bail package. And then he's also asking family members to create a media narrative. And he's asking the same family members to contact potential witnesses and potential victims. And he's asking the family members to do a PR strategy. It's just given... Never had accountability. Never had accountability. Let me get some of these super chats. Thank you so much, Chris, for the $1.49 super sticker. Abel, thanks so much for the Abel. Not sure how to pronounce it. $9.99 super chat. Little donation for the legal fund, coffee, or anything to support you and your channel. Oh, thank you so much. I know you're saying that because it's like, I have to keep reiterating for the clowns that are paid to tweet about me all day that, if you want to donate to the legal fund, as it is demonstrated many places in writing, you can donate down below. Thanks so much for that. Otherwise, these super chats are just, that's my paycheck. Like, I might use it for the legal fund. I might use it to get DoorDash. Who knows? Thank you, Morris, becoming a member. We have Ernesto. Happy to be on a live. Been following you for a while now. Amazing. Love your humor, transparency, sarcasm, knowledge, and insight. Facts ain't defamation, nor are opinions defamation. There it is. Amen. Thank you for the 1999 super chat. Milas X, thank you for the $10 super chat. Wait, what? New Life Plan conspiracy theory. Victim 2 is Big Gross Joe Sherman. I had that conspiracy theory. I don't know. Y'all probably be able to rewind, and I'm like, you know what? I'm gonna keep it to myself for right now because I wanted to do some more searching. Because Joe Sherman has demonstrated like he will sue somebody. He seems a little bit off his rocker insofar as he will sue somebody, and I don't really care, but I'm also like just trying to make sure that if he did sue me ever, it's like only, facts ain't defamation. Opinions ain't defamation. So I didn't even say it, but here we have New Life Plan. Thank you for the $4.99 super chat. Conspiracy theory. Victim 2 is Joe Sherman, and he's getting monthly allowance from Diddy. I don't know if that's true. It's a conspiracy theory, as New Life Plan said. Thanks so much for the $4.99 super chat. Okay, Meek Mill did just become very outspoken. Milas, thank you for the $5 super chat, just said. And it's almost like, yeah, daily dose of Christ. Thank you for the $5 super chat as well. The diddler really forgot jail phones are tapped. It's like, did he? Did he? Did he or didn't he? Did he do it? Did he forget? Thank you for the $5 super chat. The Last Ronin, praying someday Bieber comes and speaks out about Diddy. I'm sure they were evil thing. Look, innocent until proven guilty. I don't know. I wasn't there, but I hope that everybody that anything happened to comes out and talks about it. Thank you for that $5 super chat. New Life Plan with another $4.99. Witness 1, Corey Gamble. My other guess is Jay-Z or Ye. Witness 1. I could see how it could be any of these. Okay, I like those theories. I need to start a spreadsheet with like guesses of things. Sue Alicia, it was Kalina. She is married. Thank you for that $1.99 super chat and for the hint, the clue. Dirty Money is an American musical trio. New Life Plan. Thank you again for the $4.99 super chat. Composed of R&B singers Dawn Richard, Kalina Harper, and rapper Sean Combs. And I was reading I finally, months late, got around to reading the Dawn Richard lawsuit, and we're going to have to do a whole dedicated video. I'm trying to figure out if I want it to be a live or if I want it to be like a pre-recorded and an edited. I think it's one of the most alarming lawsuits of the whole Diddy lawsuit progeny, to be honest. And thank you for the $4.99 super chat. He called her 53 times. Sue Alicia, thank you again for the $1.99 super chat and for that context. I forever use conservatorship or jail in my daily life now. Love you, BJ. Get you a hot tea. Thank you, Sean. Thank you so much. Every time I see your profile picture, I'm like wanting to remind y'all that I have some very cool new merch that is right on the horizon. It is very cool. Because like, look at that profile picture. Y'all see that? Facts ain't defamation. Limited edition hoodie gone. Once it's gone forever. It might be gone forever already, but you can just link down below if you want it. New Life Plan. Again, $9.99. Thank you so much for the super chat. There was 2 bandmates. Dawn Richard sued, right, on September 12th. So likely the other bandmate of Diddy Dirty Money getting Diddy Dirty Money. They play in our faces. So it does look like, it does look like it was Kalina. And then they're saying in this filing, New Life Plan, they are saying in this filing, the government is that this Kalina, if it is Kalina, right? Victim 2, witness 2, whoever that is, was received money. Thank you for the $9.99 super chat. Do you think he's trying to get a mistrial? Probably. I would think. Yeah. I mean, who doesn't want a mistrial? Look what happened with Alec Baldwin. I mean, he never has to be tried over that issue ever again. So I'm assuming he would love to get a mistrial. Thank you, Nikkei, for the 199 super chat. If he behaves that way in prison, MMF said, imagine what he could do if he was out on bail. It's so true. Thank you for the 499 super chat. And obviously, very true comment. Girl, you got other creators using your content. Oh, who? That's cute. I use other people's too, though. I mean, we all out here reporting on the same thing, fighting the good fight. Obviously, you're great content. I always get my news fix from you. Well, I mean, there's maybe some news over here, but it's opinions, it's psychic visions, messages from the mothership, just all everything. It's a variety show over here. Thank you for that $5. Vanessa, welcome to membership. Stephanie Ross, $2.99 super sticker. Thank you very much. Shauna B, new member. I thought you were a member before. Welcome or welcome back to members. And YouTube offered me like a very small bonus to make 2 members only YouTube videos. So now I'm like, they did it. They incentivized me to like finally do it because we were talking about it anyway. So I'm gonna make one soon. Sublunary messaging. Thank you for the $2 super chat. Says, couldn't all this lead to additional charges? Yes, it could. It could. And you might be seeing it buzz around the internet lately, the superseding indictment. People are like, oh, when are we going to see a superseding indictment? When are we going to see the superseding indictment? A superseding indictment is just that. When there's a whole bunch of new stuff got found, and now they're going to be a new indictment had to be done. I don't know. Maybe, or maybe not. I just keep seeing people say that. Thank you for the $2 super chat. I already did this one. I do. Thank you for the 199 super chat. I do think he might be trying to, but I mean, who wouldn't, Alicia Ray, thank you for the $10 super chat. He went to jail and continued committing crimes without missing a beat. Can't believe the lawyers are in on it. I hope this buys you a cup of tea. Thank you, Alicia Ray, for the cup of tea. I appreciate it. Silly Rabbit, shout out to Silly Rabbit, modding in the chat for the 199 super sticker and all your hard work. I got the best mods on YouTube. Hands down. Oh my gosh, Maggie Battles, thank you so much for the $49.99 super sticker. I really appreciate that. Hell on earth, laissez le bon temps rouler, Misha. Thank you so much for that $2 super chat. Merci, Misha. Oh, and thank you, Mr. Lord, for the $20 super chat. Hello. I could never look as good as you. Late in the night, I look like a grandma. Y'all are funny. Why would the Fed show their hand? I don't think they're showing their hand. I don't think they're showing their hand at all. I think this is them saying we haven't even freaking started. We just getting started. Will this mean his law team has communicated pursuant to their own lawyers' conduct? I don't understand this question. Thanks so much. I'm late but slay. Yes, that is fine. Are they the best? Might have to test that out. Wait, who's the best? Okay, well, I just banned you just because you said that. So how'd that test go? Oh my God, my whole live stream went away. I mean, my whole comments thing went away. Oh, there it goes. Diddy will be in jail forever and ever, Bummer Drummer said. Can't stop, won't stop. I nailed that French. It's in my blood, girl. It's the Spanish is in there, the French is in there, the German is in there. It's just I'm all mixed up. I think they only showed a couple cards in the deck. I think so too, Morris. I think so too. They haven't put the pen down. Yeah, no, I don't think so. Can't fix stupid. Nope, sure can't. But you can sedate it. Oh my God, please. That is giving conservatorship or jail. Love you, mean it, Bella Vita. Shout out to Christy in the chat. Shout out to, I don't know if Oklahoma's in here. Shout out to you if you are. Anonymous, I don't know if you're in here. Shout out to y'all. Lola. The dollar button to the right of the chat box. Okay, so Lisa said, I mean, because there's calls to lawyers or the lawyers committing the offense. That is the question. I mean, that's kind of what I'm wondering too. It's like, is it... Yeah, we don't even know the co-defendants. It's true. Yeah, no, that's true. It's so true. No, you're right, Lola, because Lola says we don't even know the co-defendants in this RICO. They haven't released the full indictment clearly, and they haven't. The first document on the docket for the Diddy trial, for the Diddy case, the government, the US versus Combs, is a sealed indictment. And it says sealed to public. And then the second document, to my memory, it might be second or third. The next complaint is indictment is the unsealed one that we're allowed to see as the public. So yeah, I mean, good point. Wow. Who are the freaking co-defendants is the question. Other question. Dawn became a member. Welcome, Dawn, to members. Kind of sounds like he wants to stay in jail. Maybe he's safer there. You know, ever since I read that Mysterious Party That Changed Hip Hop Forever, I just think that like everybody, like the jails are just a part of it too. But I hope not. This is water, if anybody's wondering. I had such a hard time drinking out of like, I just never could do the Stanley. So I have, or like, you know, that whole like water. I just have I have to sip anyway. So that could be a cute cup. Yeah, I'm still here. What do you mean? Yeah, exactly. God's children are not for sale. I mean, yeah, exactly. Oh, Down the Rabbit Hole News is in here? Kind of sounds like he's trying to stay in jail. And thank you for that $4.99 super chat. This is the question. Who owns the jails? I mean, BlackRock, Vanguard, and you know, whoever else is invested in the private ones. Any info on Krona? I don't know what this means, Jaded Explorers. Thank you for the $10 super chat. Krona? I don't know what that means. Sorry. Am I moving to India? No. Why would I move to India? I mean, I would love to. I love India. I would love to live there. I mean, but I don't want to like move from here for like good. I would probably do like a dual, like sometime, part-time. They're going to turn that jail into Castle Freaky, he said. I don't know what that means, so I'm going to delete that one. Oh, Karina? Yeah. Well, they don't own me, but they own a lot. Well, if I moved to India, like y'all know they got internet and everything over there, I could still like pretty much do exactly the same job. Like they got internet over there in India now. I don't know if y'all heard. Actually, I uploaded from India 2 videos. Oh, well, I don't think he owns it. Yeah, he owns it. Yeah, he does own it. He founded it. Ugh. Larry Finkel. India is wow. I love it. Oh, thanks so much, Cher. From Australia, you're absolutely brilliant. And I really feel for you. The stress you must be under is wild. It is so stressful, but to be honest, I only take on like 1 to 5% of it, and the Lord takes the rest. So I'm really honestly like happy most of the time. Anyway, that's all I really had for today. In the meantime, facts ain't defamation. Oh, I will put together a video, and this was like, I mean, close to 3 hours, obviously. I'm gonna gather my thoughts and I'll put together a little TLDR version of this video. Probably not clips. I'll probably just make another one where it's like, what is the government saying? What did I find to be the most compelling, most whatever, you know, this, that, the other. It's kind of hard to get all of my thoughts out live. You know, I'm kind of still trying to be slightly concise sometimes. And all of that. So that's all I'm really gonna have for today. Notch things. Shout out to you. I got to make my way over to the DMV one of these days. Okay. This is so cool. I love it when people say this. They're like, Just found your channel. Been binging ever since. Love that. Okay, I'm going to, it's like way past my bedtime and I gotta get back to office renovations tomorrow. I'm so excited to show y'all what I got going on in there. Ugh. That's another going to be a members only video. I've been filming my little progress in there. That's all I really have for today. In the meantime, if facts ain't defamation, and neither is reading the government's response to Diddy trying to get out of jail for the second time on bail. Love you, meet. Okay, bye.